All right, are we ready to proceed then at this time? Hello?
Your Honor, the defense is ready to proceed.
All right, how about the prosecution?
The people are ready to proceed, Your Honor.
All right, well, court is now in session. I want to welcome both the CSA team and the University High team, and congratulations for getting this far in the process. Before we start, everybody take a deep breath. This is going to be fun. I know it's easy for me to say, but hopefully after this process, you will look back upon it as being fun and also informational. All right. It's just amazing that you all have gotten this far, and I hope that you get out of this process some wonderful life skills that you'll utilize for the rest of your lives. What I'd like to do at this time, because we have been presented, we meaning myself and our scoring judges, we are being presented with the all-star and the elite of two high school teams. We're very fortunate to have what I call all-stars and elite scorers. The folks that we have here today to look over your performance and judge your performance are an A team, incredibly well-respected folks within the legal community. And unfortunately, with this format, we're not going to have time. Unfortunately, we're not going to have time at the end of this proceeding for them to tell you a little bit about them, because they're wonderful mentors also. So at this time, if we can have the members of the scoring panel, please introduce themselves to our students.
I'll go first. This is Alan Carvaro. Good evening, everyone. Congratulations. Just being here, you're all winners already. My name is Alan Carvaro. I have served 28 years in the Orange County Public Defender's Office. And for the last decade, I have have my own private practice. I do basically criminal defense work. So I welcome you all. I look forward to the tournament. With that, I'll pass it on to the next scorer. Thank you.
I'm unmuted. I can go next. Good evening. My name is Karen Scott, and I am a federal magistrate judge here in Orange County. I've been in that position for about 6 years. Prior to that, I was a civil litigator in Orange County for about 20 years. And perhaps more importantly, prior to that, I was an Orange County High School mock trial student. So I know that it's a little nerve-wracking to be in your position this evening, but I do wish everyone the best, and I'm looking forward to seeing everyone's performances.
Good evening, everyone. My name is Toni. I'm a business litigation partner at Snell and Wilmer, and I just want to congratulate both teams for getting this far, and I hope you have fun tonight.
Good evening. I'm Jeff Blank. I've been a mock trial coach here in Orange County for the last 10 years. Took this year off, so I'm well rested for tonight's matchup. I've also been a presiding judge at the state finals for the last 4 or 5 years. After our team won the county championship about 5 years ago, I've been presiding over the state finals. Since our team hasn't been as fortunate as the two teams tonight, it takes a lot of work. Orange County, so competitive, so it's an honor just for you guys just to reach the final round, regardless of who wins. When not doing something related to mock trial, I do business litigation and sports law. Just completed a jury trial at the Westminster Courthouse last week. And several former mock trial students of mine actually are working for my firm right now and doing really great work. So good luck, guys, tonight.
Good evening, everyone. My name is James Arias. I'm an associate at Wilson Sonsini, Goodrich, and Rosati in Palo Alto. I'm in the Complex Commercial Litigation and Government Investigations program. We call them programs now, but yeah. So I actually did mock trial in high school, and then I helped CRF-OC do Orange County mock trial 5 years ago, and I was on the other side helping out with all the scoring and such. And so I think they just brought me in because I have an in-depth understanding of what goes on behind the scenes, and I've also been a competitor not too long ago. So good luck to everyone.
Good evening, everyone. I'm Lisa Mitz-Patrick, also a civil litigator for decades now, and I coached mock trial for many years. I've scored many years before that, but I most enjoyed my 8 years coaching. Our team did really well. We got into the top 8, but never quite where you guys are. So congratulations for the hard work, especially in this new remote environment, which has its own interesting things, but great experience, because I'm sure Judge Jensen can tell you that we're kind of moving in that direction as a court system too. So good luck to you all. We'll give you some great feedback and hopefully you keep going.
Welcome, everybody. Congratulations to both teams. My name is David Outwater. I'm a business litigator here in Orange County. I'm a past president of the Constitutional Rights Foundation, which puts this on, and a proud coach of a team for 17 years. It's been a while, but that team had the benefit of being in this final round a number of times and going to state quite a bit. And so very experienced and very excited to see the trial tonight. So thank you.
All right, I think that will take care of all of our wonderful scores. I am just happy they're not scoring me, but they're scoring you. So with that, if we can help myself as well as the attorney scores, if the prosecution team at this time would be kind enough to state their name and role, please.
Good evening, Your Honor. My name is Reagan Matting, and I am from the Orange County School of the Arts. This evening, I will serve as pretrial counsel for the people of the state of California. At this time, trial counsel would like to introduce themselves.
Good evening, Your Honor. My name is Cobey Eisenberg, and I am lead trial counsel for the people. Tonight, I will be conducting the closing argument, as well as the direct examination of Dr. Charlie Dunn and the cross-examination of Dr. Tyler Clay.
Good evening, Your Honor. My name is Emma Kay, and I am trial counsel for the people. I will be delivering the opening statement and conducting the direct examination of Angel Russell and the cross-examinations of Jamie Cobey and Dani Emling.
Good evening, Your Honor. My name is Jocelyn Wang, and I am trial counsel for the people. Tonight, I will be conducting the direct examinations of Terry Edwards and Deputy Sheriff Toni Garrett, as well as the cross-examination of Francis Yazzie. At this time, our witnesses would like to introduce themselves.
Good evening, Your Honor. My name is Ashley Hodge, and I will be portraying the role of Terry Edwards.
Good evening, Your Honor. My name is Joshua Hizon, and I will be portraying the role of Angel Russell.
Good evening, Your Honor. My name is Claire Carr, and I will be portraying the role of Dr. Charlie Dunn.
Good evening, Your Honor. My name is Sarah Demeter, and I will be portraying the role of Deputy Sheriff Toni Garrett. At this time, our clerk would like to introduce herself.
Good evening, Your Honor. My name is Elaine Lim, and I'll be assisting the court as clerk and official timekeeper. At this time, our substitutes would like to introduce themselves.
Good evening, Your Honor. My name is Daisy No, and I will serve as the substitute for pretrial counsel in the event of technical difficulties.
Good evening, Your Honor. My name is Shruti LA, and tonight I will serve as substitute for all witnesses in the event of technical difficulties. At this time, our coaches would like to introduce themselves.
Good evening, Your Honor. I'm Ethan Fang, and together with Halim Donadina, Melissa Brandman, and Whitney Coates, we're the coaching staff of OSHA.
All right, well, thank you very much to the prosecution team. And with that, then I'd like to turn it over to the defense team. And if you would be kind enough again to state your name and role, that would be wonderful.
Good evening, Your Honor. Scorers. My name is Charlotte Behrens, Behrens. And tonight, I will be presenting the pretrial motion on behalf of the defense. At this time, with the court's permission, may our team trial attorneys please introduce themselves.
Yes, please do.
Good evening, Your Honor. Scores. My name is Erin Junn, Jeon, counsel for the defense. Tonight, I will be conducting the direct examination of Jamie Cobey and the cross-examinations of Terry Edwards and Deputy Sheriff Toni Garrett. Additionally, I will be delivering the defense's opening statement.
Good evening, Your Honor. Scores. My name is Krishna Kawani, Khawani, counsel for the defense. Tonight, I will be conducting the direct examination of Dani Emling and the cross-examination of Angel Russell.
Good evening, Your Honor. Scores. My name is Daniel Delpasand, DELPASSAND, Counsel for the Defense. Tonight, I'll be conducting the direct examinations of Dr. Tyler Clay and Francis Yazzie and the cross-examination of Dr. Charlie Dunn. Additionally, I will be delivering the defense's closing argument. At this time, with the court's permission, may our team's witnesses please introduce themselves.
Please do.
Good evening, Your Honor. Scores. My name is Graham Nyland, Nylen, and tonight I'm Dr. Tyler Clay.
Good evening, Your Honor. Scores. My name is Ryan Alavi, ALAVI, and tonight I'm Francis Yazzie.
Good evening, Your Honor. Scores. My name is Simona Forster, FORSTER, and tonight I'm Dani Emling.
Good evening, Your Honor. Scores. My name is Andy Kessler, KESSLER, and tonight I am Jamie Cobey. At this time, with the court's permission, may our team's substitutes and clerk please introduce themselves.
Good evening, Your Honor. Scores. My name is Christopher Burke, BURKE, and tonight I am the court's clerk. I have video and audio cues for 2 minutes, 1 minute, 30 seconds, and stop. As for the mock trial virtual rules of 2022, I will be giving these cues for the defense case in chief as well as the pretrial motion.
Good evening, Your Honor. Scores. My name is Karina Ponderangadu, PANDURANGADU, and tonight I'm a substitute for the defense.
Good evening, Your Honor. Scores. My name is Porvi Kaney, KHENI, and tonight I am a substitute for the defense.
Good evening, Your Honor. Scores. My name is Evan Cho, CHOE, and tonight I am a substitute for the defense. At this time, with the court's permission, may our team's teacher advisor and attorney coaches please introduce themselves.
Certainly.
Good evening, Your Honor. Scores. My name is McKenna Morris, teacher advisor for University High School.
Good evening, Your Honor. Scores. My name is Neil McCann, one of University High School's coaches.
Good evening, Your Honor. Scores. Sue Lee, attorney coach for University High School. This concludes the defense introduction. Thank you.
All right. Well, thank you very much for that. One thing I would like to pass along to the clerk, many rounds ago, I had some issues with timing and clerks not being on the same page with each other, and it did create some issues. So to avoid any timing issues, I would recommend, but it's optional, that both timing clerks may want to use the chat feature for time checks during this process. Of course, you're familiar with the rules and when and how it's appropriate to bring to the court's attention any discrepancies. I don't anticipate any, but just in case. Again, as you know, you must complete your presentation within the specified time limits. Again, as the clerks have indicated to you, they will signal to you your time for each section of the presentation as it begins to run out. When your total time for each section runs out, you'll be stopped even if you've not finished. And attorneys must call, of course, all 4 witnesses within your allotted time frame. Again, this is a bench trial. I like to look at this as this is all about the journey. It's not about the end. And by that, I mean, it's not about the verdict. The teams will be rated based on the journey. That is the quality of your presentations, independent of the verdict I may render at the conclusion of this case. And that holds true also, I think, for the motion also, depending on how I rule on that. So please don't take anything from either one of those rulings. Now, barring any unforeseen circumstances, and oftentimes it is a challenge with this new format, no recesses will be called. If for any reason a recess is necessary, again, team members should remain in their appropriate places and should have no contact with spectators or coaches. If there's some type of technical difficulty, we'll abide by the rules and deal with it accordingly. And if it's not in the rules, we'll just deal with it. So let's just not all freak out, okay? Remember, again, the objections are limited to the California Mock Trial Simplified Rules of Evidence located in the case packet. I like to preside over these type of proceedings as if I have a court reporter. So if for some reason you're too fast, or I can't hear you, or I can't understand you, I may ask you to repeat yourself or to slow down, not only for my purpose, but also for the imaginary court reporter, but more importantly, for our scoring judges. You have a lot of great things to say, but if you say it too fast and we can't understand it, it will be lost. We want to reward you for all the words that you are going to be speaking today, all right? So if there are no questions, then we will move then forward to the pretrial arguments at this time. Both sides have 4 minutes again to present their arguments. The defense will begin first. I will interrupt to ask clarifying questions. Of course, time spent answering my questions is not included in your 4-minute time limit. At the conclusion of your arguments, each side will be offered 2 minutes of rebuttal time. Again, remember that the rebuttal time, although it might be tempting to bring in some new things, again, the rebuttal time is to be used to counter your opponent's arguments, not to bring in something that maybe you forgot. Again, it cannot be used to raise new issues. So is counsel for the defense ready to begin then for the pretrial motion?
Yes, Your Honor. May I proceed?
Yes, whenever you're ready, counsel, you may proceed.
The Fourth Amendment provides individuals with protection against unreasonable searches and seizures. In the case at hand, my client, over the span of 6 months, was recorded by the police with no warrant. This surveillance of Mr. Cobey was a direct violation of his Fourth Amendment rights for 2 main reasons. First, the circumstances of my client's surveillance gave police excessive and unreasonable access to Mr. Cobey's backyard. Second, said backyard was within the curtilage of Mr. Cobey's home and therefore has protection under the Fourth Amendment.
Well, you jump right there to the big issue, protected curtilage, expectation of privacy. What is it about this gentleman's backyard that even gives any expectation of privacy, let alone a protected curtilage?
Your Honor, the standard of curtilage is seen in the case of United States versus Dunn, where the curtilage of the home is defined through the proximity of the area claimed to be curtilage, whether the area is within an enclosure surrounding the home, the uses to which the area is put, and the steps taken by the resident to protect the area from observation of people passing by.
All right, familiar with the 4-part Dunn test. So tell me how somehow your client complies with that.
Your Honor, Mr. Cobey's backyard was small, located directly outside of his home, and enclosed on all sides by a variety of fences. Furthermore, when Mr. Cobey discovered that he was being filmed by Eric Smith, he demanded that this camera be taken down, expressing his reasonable expectation to privacy within this area.
Well, now I have surveillance cameras on my second story in my house for protection, okay? And of course, they pick up my backyard and they pick up my neighbor's yard, okay? So are you telling me now that if my neighbor says I don't like that, I have to tear all those down and be subject to somebody who maybe I sentenced to prison and got out and wants to kill me?
Your Honor, this is not a matter of Mr. Cobey's consent. The fact that he stated that he was not comfortable with this surveillance simply displays his reasonable expectation of privacy within this area. Furthermore, the fact that this backyard meets the standard of curtilage means that a search warrant must have been used by the police to film this area lawfully.
Well, now how is this different though? In Dunn, you had aerial photographs, okay, taken, all right? Or let's say California versus, and I'm probably mispronouncing it, Caracciolo, okay? A plane flew over. How is this camera, other than it doesn't fly, any different? It's taking pictures from an elevated position. How is it any different?
Your Honor, the main differences between these two cases is time. For example, in the case of Cirello, the aerial camera that flew over the defendant's house flew over this area only once. While in the case of Mr. Cobey, my client was recorded over the span of 6 months.
Yes, but it was, when you say recorded for 6 months, it was set on a motion detector. So it wasn't 24/7, 6 months. It was whenever that motion detector was tripped. We don't know whether it was tripped one time a day or 100 times a day. And if you were to aggregate all the times it was tripped and filmed, it probably wouldn't even come close to being over a couple days. I don't know.
Yes, Your Honor. While the camera watching my client was motion detected, the fact remains the same that this camera over the span of 6 months was never turned off. This gave police unreasonable access to my client's backyard, as they would not have been able to reasonably stand outside of my client's home for 6 months to watch any time that he moved.
Well, they could have, they backed up to, I think, was it state land or park land there? They could have just set something up there and done a surveillance, right?
Yes, Your Honor, but the use of technology is what gave the police excessive access to my client's backyard.
All right, go ahead.
For these reasons, the defense requests that the court find this bracketed evidence to have been unlawfully obtained and therefore excluded from tonight's trial. First, the circumstances of my client's surveillance gave police both excessive and unreasonable access to Mr. Cobey's backyard. As seen in the case of People versus Weaver, a police officer with no warrant placed a GPS on the back of a defendant's truck for 65 days. Now, this was deemed a violation of the defendant's Fourth Amendment rights due to the extended amount of time in which he was filmed, as the police would not normally have this much access to surveillance data.
Well, you keep on now mentioning time. So like what, under 10 it's okay, above 10 it's not okay? What's the bright line here?
Your Honor, while none of the case precedents in which we are given state a specific amount of time which qualifies surveillance being unreasonable, I'm using the extensive precedent as seen in the case of People versus Weaver to compare to the case at hand, in which 65 days is deemed excessive. The amount of time in which my client was recorded, which was over 200, must be considered excessive as well.
Thank you, go ahead.
Furthermore, this camera was provided to Eric Smith by the police and filmed my client on behalf of law enforcement. Over the span of 6 months, Mr. Cobey was filmed in his own backyard by the police. The extended amount of time in which he was filmed gave the police both excessive and unreasonable access to his backyard with no warrant, and therefore cannot be included in tonight's trial. Second, Mr. Cobey's backyard was within the curtilage of his home and therefore is granted protection under the Fourth Amendment. As I've already stated, my client's backyard meets the standard of curtilage which is seen in the case of United States versus Dunn. Furthermore, when Mr. Cobey discovered that he was being filmed by Eric Smith, he demanded that this camera be taken down as the recording made him severely uncomfortable in this area of his home.
What about if we did use a drone? You know, drones are real popular now. What if what if they just want to fly a drone over and then let it hover over the property? How is that any different than this camera?
Well, Your Honor, as seen in the case of California versus Cirillo, an aerial camera was flown over the defendant's house once. The difference between these two cases is both the time and the detail of the two cameras. So I've already stated, my client was being watched for 6 months, while a drone could only capture one moment of footage. Furthermore, the camera monitoring Mr. Cobey was elevated from 10 feet in the air, while a drone could be elevated from up to 1,000. The difference in quality and detail of these cameras is what distinguishes these two cases.
Thank you.
Through these details, it is shown that Mr. Cobey's backyard was within the curtilage of his own home, and furthermore, that my client expressed his reasonable expectation of privacy within this area. For these reasons, a warrant was required by the police for this area to have been surveilled lawfully. Under the Fourth Amendment, my client has protection against unreasonable police searches and seizures. The actions of Eric Smith on behalf of law enforcement is a direct violation of these inalienable rights. For the reasons which I have previously stated, both the extended amount of time in which the police filmed my client, and because of the fact that this filming took place on Mr. Cobey's curtilage to his home, the defense once again requests that the court find this bracketed evidence to have been unlawfully obtained and therefore excluded from tonight's trial. Thank you.
Thank you very much, counsel. Appreciate the argument. And at this time then, is counsel for the prosecution ready to proceed?
Yes, Your Honor.
Whenever you're ready, ma'am.
The prosecution respectfully requests that the court denies the defense's motion to exclude Exhibit A, the image of the snake feeding tongs, as their recovery was wholly consistent with the Fourth Amendment. This is true for two main reasons. First, the area in which the tongs were located is not protected as curtilage under the Fourth Amendment. And
Why?
second,
What is it about the property that doesn't make it curtilage? If you apply, whether it be the Dunn test or other tests that have been articulated in the case authority.
well, Your Honor, the facts in the case at hand do not meet the standards set by the case of United States versus Dunn. In Dunn, a 4-part curtilage test is established, and the fourth part of the test, the defendant taking steps to protect their yard from public view, has not been satisfied.
Why is that? Because you just didn't do a 20-foot fence instead of a 6-foot fence?
Well, Your Honor, in the case of Schaefer versus City of Boulder, the defendant took additional steps in order to protect their yard from being captured by the camera, and that is why the backyard was deemed to be curtilage. However, in this case, no such steps were taken, and therefore the backyard is not curtilage.
Wait, what did the client in Schaefer do that to further protect other than what was normally attached to the house? This was a camera pointed at somebody's bathroom window.
Yes,
right?
Your Honor. And in the case of Schaefer versus City of Boulder, the defendant built up multiple feet of fence and called the police on numerous occasions to report the camera.
Well, he had 4 to 5 foot high wooden fences. Isn't that about what we have here?
Your Honor, the height of the fence is not what's important, but rather the defendant displaying that they have a reasonable expectation of privacy in this area. And
Yeah, what was missing? I mean, you had a fence around the property. You had one little gate that goes out to the private land or the public property in the back there. What more did he need to tell everybody, this is my curtilage, stay away?
Well, Your Honor, even if Your Honor finds that the area in which the evidence was located was in fact curtilage, in the case of California v. Sorrello, the court found that the Fourth Amendment protection of the home and curtilage is not absolute. The court explained that if the information was obtained in an area which was publicly navigable or a manner which was non-intrusive, then the Fourth Amendment was not violated regardless if the area search was curtilage.
So if someone decides to fly a drone over my backyard for hours and just watch what I'm doing and stuff like that, that's reasonable then?
Well, Your Honor, if parts of your backyard are in public view from, as in the case at hand, directly adjacent state park land, and you are aware that it is in public view and you have not taken any steps to protect your yard from public view, then no, the Fourth Amendment is not implicated.
Well, actually, you know, the electrical company has an easement behind my backyard, so they have free access there. So I guess the electrical company can then spy on me now then? Is that okay? Because it's.
Well, Your Honor, based on the totality of the circumstances, not only did the defendant not have a reasonable expectation of privacy, but the defendant also did not have a protection of curtilage. Your Honor, the defendant was aware that Eric Smith frequented their backyard without permission nor warning. The defendant was also aware that there was a camera pointed in the general direction of their yard for 200 days, that there was a sign announcing its presence, and Jamie Cobey did nothing in order to protect the yard from being captured by the camera. They did not install a locking mechanism on the gate. They left the tongs out in plain view.
Oh, so I guess if he had put a lock on the gate, then that would have been a big difference.
Well, Your Honor, that combined with the totality of the circumstances, yes.
Okay, go ahead.
Thank you. The facts of the case support that the Fourth Amendment was not violated. Allow me to summarize. On October 10th, 2020, the police gave Eric Smith a smart camera for use to protect his backyard. The camera picked up portions of Jamie Cobey's backyard.
Oh, no, I'm familiar with the facts. Right, yeah, the police said, here, set this up. We're sick and tired of the two of you squabbling. Find some evidence, and if it's there, we'll arrest somebody.
Well, that's not exactly what happened, Your Honor. It was a long dispute between the two neighbors, that's true, and the camera was given to Eric Smith in order to protect their backyard, after Eric Smith believed that Jamie Cobey had broken into their backyard.
Go ahead.
Thank you. The snake tongs were visible from the publicly navigable state park land that was directly adjacent to Jamie Cobey's backyard and could be seen through the chain link fence. First, the area in which the tongs were located is not protected as curtilage under the Fourth Amendment. In the Supreme Court case of United States versus Dunn, the court established a 4-part curtilage test. The defense must prove that all 4 parts of this test have been met. The defense has not done so. The 4th part of the test, taking steps to protect the yard from public view, has not been established.
Is your argument that the tongs were in public view by virtue of the one gate that wasn't completely covered?
Well, Your Honor, yes. Standing on the directly adjacent state parkland, someone could have looked through the chain link portion of the fence and seen the snake tongs, deeming them to be in public view.
Okay, go ahead.
Thank you. The defense must prove that all 4 parts of the Dunn test have been met, and the defense has not done so. The 4th part of the test, taking the steps to protect the yard from public view, has not been established. In the case of Schaefer versus City of Boulder, the defendant took additional steps in order to protect their yard from being captured by the camera, and that is why the backyard was deemed to be curtilage. However, in this case, no such steps were taken. The defendant in Schaefer built up multiple feet of fence and called the police on numerous occasions. In this case, no such steps were taken. However, even if Your Honor finds that the area in which the tongs were located was in fact curtilage, in the case of California v. Sorrello, the court established that the 4th Amendment protection of the home and curtilage is not absolute. The court went on to explain that if the information was obtained in an area which was publicly navigable or in a manner which was not intrusive, then the 4th Amendment was not violated, regardless if the area searched was curtilage.
So I guess in retrospect, they should have put a lock on the chain link fence, and if the chain link fence had been, had coverage, then that would have been fine, or still because it backs up on public property, someone could put a ladder up there and just spy on you all they want.
Well, Your Honor, due to the presence of the chain link fence, it is reasonable to come to the conclusion that someone could have looked through the chain link fence and seen the unconcealed snake tongs. In the case of Katz versus United States, the court established that the 4th Amendment is not implicated if the defendant has not taken sufficient steps in order to protect the evidence. In this case, the defendant did not take sufficient steps, and therefore the 4th Amendment is not implicated. No, Your Honor.
All right, go ahead. Thank you.
Thank you. Your Honor, in this case, the tongs were viewable from the publicly navigable state
2 minutes.
land, and there was no physical intrusion onto the defendant's property. Furthermore, the camera's purpose was to protect Eric Smith's yard. Furthermore, the case of Katz versus United States establishes that there must be both a subjective and objective reasonable expectation of privacy present in order for there to be a reasonable expectation of privacy. Your Honor, in this case, there was neither. There was no objective expectation of privacy because Jamie Cobey was aware that Eric Smith frequented their backyard without permission nor warning. Cobey was also aware that there was a camera pointed in the general direction of their yard for 200 days.
But and he complained. What else was he supposed to do? Shoot it and disable it? I mean, he complained. Nothing happened. So what more does he need to do?
Well, Your Honor,
he couldn't afford to take him to court and get an injunction or anything. Probably. What else could he do?
Well, Your Honor, the defense simply mentioned the camera in a passing remark during a frequent argument between Eric Smith and Jamie Cobey. The defendant would have to take additional further clear steps in order to establish that they had a reasonable expectation of privacy.
Well, what would that be? Does he put, like, instead of no trespassing signs, does he need to put up, I have an expectation of privacy on this property to everybody?
Well, Your Honor, if something is in plain view and the defendant has not taken sufficient steps to protect it from public view, then not only is there no reasonable expectation of privacy, but the 4th Amendment is not implicated. And this situation, which is established in the case of Katz versus United States, applies to the case at hand, because the tongs were visible from the publicly navigable state park land due to the presence of the see-through chain link fence. Jamie Cobey took no steps in order to conceal the tongs.
All right, go ahead.
Furthermore, Jamie Cobey was aware that Eric Smith frequented their backyard without permission or warning. Cobey was also aware that there was a camera pointed in the general direction of their yard for 200 days. Cobey did nothing in order to protect their yard from being captured by the camera, did not install a locking mechanism on the gate, and left the tongs out in plain view.
1 minute.
So, Your Honor, because of the totality of the circumstances, the defendant did not have a subjective expectation of privacy and therefore no reasonable expectation of privacy.
What about an objective level of privacy? I mean, you talk about totality of circumstances and all these things he should have done. I mean, you probably can't find a backyard in this country where you couldn't say somebody should have done something. But isn't there just a reasonable, objective expectation of privacy that when you're in your backyard, you are not going to be spied on?
Not necessarily, no, Your Honor. Although it may be a hard pill to swallow that we do not have privacy in all situations in our backyard, allow me to present a hypothetical to you. Imagine that your swimming pool in your backyard directly backs up to your neighbor's window, and your neighbor can look through that window at any time in any day and look through and see what you're doing in and around your swimming pool. Your Honor, in that hypothetical, it is clear that you would not have a reasonable expectation of privacy in your yard, as you are aware that someone could look in at any time. Although that may be hard to grapple with, that is the facts of the case at hand and what the Supreme Court has outlined.
Right, but I have an expectation of privacy that they're not shooting a camera inside to my home and seeing what I'm doing.
Well, Your Honor, in this case, the defendant would not have an expectation of privacy, as the defendant made it clear that they were aware of the camera's presence.
All right, go ahead.
Furthermore, the case of Katz versus United States establishes that if something is in plain view and the defendant has not taken sufficient steps in order to protect it from public view, then it is not protected by the Fourth Amendment. This holding applies to the case at hand, as the tongs are viewable from the publicly navigable state parkland, and Jamie Cobey took no steps in order to control the state tongs, and therefore the Fourth Amendment has not been implicated. Your Honor, the purpose of the Fourth Amendment is not served in excluding vital evidence that has been legally obtained in a murder investigation. For all the foregoing reasons, the prosecution respectfully requests that the court denies the defense's motion. Thank you.
Well, thank you very much, counsel. Does the defense have a rebuttal at this time?
Yes, Your Honor. May I proceed?
Yes, whenever you're ready, counsel.
I have 2 points, Your Honor. First, the people claim that my client's backyard was not within the curtilage of his home because the snake tongs were in plain view due to the chain link fence. However, if I may direct you to the case of Romero Bustamante, it is seen the defendant's backyard, partly protected by a chain link fence, still falls under the standard of curtilage to the home. The same can be said for the case at hand. While a small portion of my client's backyard was protected by a chain link fence, this does not mean that this was in plain view, as the camera recording my client was elevated from 10 feet in the air. Therefore, it is not reasonable to assume that a person simply looking over my client's chain link fence could have the same view of the snake tongs as the camera did.
Well, but isn't the argument that it's plain view based on the fact that that plain view observational area of the fence is on public land?
Yes, Your Honor. While the part of my client's backyard that was protected by a chain link fence was on public land, this does not mean that it was within plain view. As I may direct you to the case of Romero Bustamante again, the defendant's backyard was still deemed the curtilage of his home, despite the fact that part of his backyard was protected by this chain link fence. The same can be said for the case at hand. My client's backyard was still within the curtilage of his home.
All right, go ahead.
Second, the people bring up the case of Katz versus the United States, claiming that my client did not have a subjective or objective expectation to privacy within this backyard. However, as Your Honor rightfully pointed out, my client expressed his reasonable expectation of privacy through the statement that he did not agree with this surveillance of his backyard. Furthermore, Mr. Cobey's backyard was completely enclosed on all sides, giving him an objective, reasonable expectation to privacy of this area. Under the Fourth Amendment, my client has protection against unreasonable police searches and seizures. For the reasons previously stated, the defense once again requests that the court find the bracketed evidence to have been unlawfully obtained and therefore excluded from tonight's trial. Thank you, Your Honor.
Thank you very much, counsel, for your zealous advocacy. It's appreciated. Does the prosecution have a rebuttal at this time?
Yes, Your Honor. May I proceed?
Whenever you're ready, counsel.
Thank you. Your Honor, the defense has not proven that the Fourth Amendment was violated. Now, Your Honor asked opposing counsel about why does the backyard have a reasonable expectation of privacy and curtilage. Your Honor, the backyard does not. The defendant did not have a reasonable expectation of privacy in their backyard because of the totality of the circumstances. Furthermore, the Dunn curtilage test has not been satisfied due to the fourth prong, the defendant taking sufficient steps in order to protect their yard from public view. Furthermore, in the case of California v. Serralo, the court found that if there has been no meaningful interference with the defendant's privacy and if the evidence is viewable from publicly navigable space, then even if the court finds the area to be curtilage, that does not mean it is protected as curtilage. And this applies to the case at hand, as the tongues are viewable from the publicly navigable state park land, and there was no meaningful interference with the defendant's privacy. Now, Your Honor correctly mentioned during opposing counsel's argument that the camera was motion detected.
1 minute.
And was not constantly given 24-hour surveillance for 6 months. And Your Honor was correct in that notion. It was detected by people in a rural area, and therefore the surveillance was not as time-consuming as opposing counsel made it out to be. Now, opposing counsel mentioned the case of People versus Weaver. However, Weaver is solely persuasive and non-binding, and therefore Your Honor must rule with cases such as California v. Serralo, in which it is found that the Fourth Amendment was not
30 seconds.
Now, Your Honor also brought up, not Your Honor, opposing counsel brought up the case of Romero Bustamante. However, that case is distinguishable from the facts in the case at hand. As in Romero Bustamante, there was a physical intrusion onto the defendant's property. In this case, there was none. And so, Your Honor, for all the foregoing reasons, the prosecution respectfully requests that the court denies the defense's motion. Thank you.
Thank you also, counsel, for your zealous advocacy on behalf of your client. The court, having read and considered your respective points and authorities that were filed earlier before this proceeding, as well as the supplemental argument that both of you have made, the court will rule as follows. The court finds, looking at the totality of the circumstances, that Mr. Cobey's backyard was part of the curtilage surrounding his home, and that one would have a subjective as well as an objective expectation of privacy that society would view as reasonable. Therefore, the still shot of the snake tongs was an illegal search within the Fourth Amendment, and therefore the motion is granted. All right, thank you very much again, counsel, and let's move on then to the trial evidentiary portion of this case. And let's see, moving on then. Prosecution and or defense, do either one of you have any physical evidence that you would like to present at this time for inspection?
Yes, Your Honor. I believe the court has access to exhibits B through E. We will be referring to these throughout the trial.
All right, then, no problem at all. And I'm sorry, that was the prosecution, correct? Right, okay. And defense, you have anything?
No, Your Honor.
Okay. All right. As we're aware of, the charges in this matter as follows. The people of the state of California are charging the defendant, Jamie Cobey, with first-degree murder in count 1 and a lesser included offense or alleged offense in count 2 of voluntary manslaughter of Eric Smith. At this time, the court will entertain opening statements from counsel. Prosecution, are you ready to present your opening statement at this time?
Yes, Your Honor.
All right, counsel, take a deep breath, relax. Love to hear from you.
Thank you, Your Honor. The most dangerous creation of any society is the man who has nothing to lose. Your Honor, this is a case about a man who had nothing left. Jamie Cobey was unemployed and had only one good friend. He was constantly engaging in screaming matches with his landlord, who he despised. He was cooped up in his home 24/7, providing constant care to his ill mother. But in the end, he lost her too. Today, you will hear from Miss Terry Edwards, a neighbor of the defendants and fellow tenant of Eric Smith's. She will testify to the long-standing rivalry between the two. They fought constantly over everything from damaged property to missing rent checks to loud music blasting in the middle of the night. Mr. Smith constantly threatened the defendant, but the defendant was not a doormat in this situation, Your Honor. He fought back, once even scattering animal feces all over Mr. Smith's front lawn. On April 22nd of 2021, the defendant had yet another fight with his landlord, where Mr. Smith shut off Mr. Cobey's electricity. And this time, Your Honor, without the electricity needed to power the defendant's mother's oxygen machine, she went into cardiac arrest and died that same day. The defendant was furious. And when Mr. Smith showed up to his mother's funeral, unannounced and uninvited, Jamie Cobey had had enough. He went around the reception saying that this was it and that he was finally going to do it. The defendant was very knowledgeable of the local flora and fauna as a gardener, but took a special fascination with rattlesnakes. In his home, he kept several books on snakes, a jar full of severed rattles, and a multitude of snake handling equipment. Later on the night of the funeral, the defendant was spotted by Terry Edwards working in his garden at the time of day the desert is most swarming with snakes. And Miss Edwards will testify today that while working in his garden, the defendant proclaimed, "I am going to kill him." He was going to kill him. Angel Russell, a line worker, will testify that the next morning, while working on the lines of Raptor Road, he saw the defendant carrying a large animal trap from his house to Mr. Smith's mailbox. And today you will hear from Deputy Sheriff Toni Garrett, who will tell you that the defendant's fingerprints were found all over this mailbox, and that while the defendant claims this is because he was dropping off rent money, this rent money in question was never actually found. When Mr. Smith reached into that mailbox later in the day, a Mojave rattlesnake that had been stationed inside latched onto his wrist and delivered a lethal dose of venom. Today, you will hear from Dr. Dunn, who will tell you in her expert opinion that this bite is without a doubt what killed Mr. Smith. The most dangerous creation of any society is the man who has nothing to lose. And Jamie Cobey had lost everything. His life had already been shattered. What was one more broken piece? Your Honor, today the people will prove to you beyond a reasonable doubt that the defendant decided to take revenge by planting a snake in Mr. Smith's mailbox. And that is why, Your Honor, at the end of today's proceedings, the people ask you to render a verdict of guilty. Thank you, Your Honor.
Thank you very much, counsel. At this time, the court will entertain an opening statement from the defense whenever you're ready.
Yes, Your Honor. Don't ignore nature. Your Honor, while the people may paint Eric Smith's death as unnatural and the result of an orchestrated murder, if there's one thing you'll learn tonight, it's that the people have ignored the natural explanations for Eric Smith's death and the nature of the man that they have accused. Jamie Cobey has been a resident of Bernsley County for the past 10 years, along with his mother, who suffered from a chronic respiratory disorder. He served locals at a restaurant, and when the pandemic hit, he became his mother's full-time caregiver, doing his gardening work on the side. Now, Mr. Cobey is a man of nature. He specializes in sustainable desert gardening, which is one of his greatest passions, and he participates in multiple groups for animal rights. Now, you heard that Mr. Cobey and his landlord, Eric Smith, didn't always get along. But it wasn't just Mr. Cobey. The evidence tonight will show that Mr. Smith had a reputation around town for being rude, and he started to turn off the power to his tenants' homes, even endangering the life of Mr. Cobey's mother. Now, the prosecution will have you believe that this is what sent Mr. Cobey over the edge, and it sent him into some murderous rage, but they will fail to prove this tonight. You'll hear from Dani Emling, a former tenant of Eric Smith's, and she'll tell you that she also got into arguments with him. That was simply the nature of the relationships he had with his tenants. Francis Yazzie, a friend of Jamie Cobey's, will testify that after his mother's funeral, after everything Eric Smith had said, Mr. Cobey brushed it off and went on home to his garden. Now, Mr. Cobey will tell you himself tonight that that was because he didn't blame anybody for his mother's death. He saw it as a natural end to a losing fight against illness. And just as that was natural, herpetologist Dr. Tyler Clay will explain to you that snakes naturally seek out cool and dark places to hide in during the day. And the snake in this case could have been in the mailbox for just that reason. After hearing all the evidence tonight, you'll find that the people have ignored nature. Both the reasonable and natural explanations for Eric Smith's death and Jamie Cobey's nature to preserve life, not destroy it. Thus, at the end of tonight's trial, my co-counsel, Mr. Delpasand, will ask the court to find Mr. Cobey not guilty. Thank you.
Thank you very much, counsel. At this time, we'll enter into the evidentiary portion of this proceeding, and with that, the prosecution may call their first witness.
Yes, Your Honor. The people would like to call Terry Edwards to the stand.
All right, I forgot before I do that, I'm sorry, I did forget to swear in all of our witnesses at this time. My apologies here. If we can have all the witnesses, please all jump in. Let me just swear you all in, and my apologies that we didn't do that beforehand here. So I see lots of little faces popping up here. So I'm going to assume that all of our witnesses have then appeared. And at this time, will both prosecution, now that both prosecution and defense witnesses have turned on their cameras and have unmuted their microphones, please. Witnesses, will you be kind enough to please raise your right hand? All right. You solemnly affirm that the testimony you're about to give in this trial will faithfully and truthfully conform to the facts and the rules of the mock trial competition. If so, please respond by saying, I do.
I do.
I do.
All right, then thank you. Y'all can turn off your cameras and mute your microphones. And with that, now the prosecution, the court having sworn in all the witnesses, you may now call your first witness.
Yes, Your Honor. The people would like to call Terry Edwards to the stand. May I proceed, Your Honor?
Yes, ma'am, whenever you're ready.
Good evening, Miss Edwards. Could you briefly introduce yourself to the court?
Sure. My name is Terry Edwards. I live in Burnsley, and I'm currently working on being a writer.
Miss Edwards, how long have you lived in Burnsley?
I moved out here about 10 years ago when I retired from being a lawyer to really focus on my writing.
Miss Edwards, do you know the defendant, Jamie Cobey?
I do. We've been neighbors since I moved.
And do you know the victim, Eric Smith?
Yeah. Yeah, we were neighbors too. He was actually Jamie's landlord before he passed.
And based on your experience, what was their relationship like?
Gosh, where do I begin? There's enough drama between them to fill a book.
Can you give us just a few examples?
Eric was always complaining to me about Jamie not paying rent. Jamie vandalized Eric's property. It all came to a head at Jamie's mother's funeral, and that's just the tip of the iceberg.
Miss Edwards, were you at the funeral?
I was.
And when was this funeral?
That was April 28th of last year, 2021.
Miss Edwards, did anything significant happen at the funeral?
I noticed that Eric Smith was there. He hadn't been invited, so Jamie understandably seemed quite upset. They actually got into a screaming match at one point during the funeral.
What was the defendant saying?
So many things. Just to name a few, Jamie said, "Leave, my mom hated you, and you killed my mom."
Did the defendant say anything else?
In hindsight, Jamie was saying some pretty ominous stuff. He said that this was it, and that he was finally going to do it.
Miss Edwards, did you see the defendant again after the funeral?
I did. I went to his house a few hours after the funeral at dusk, and I found him gardening.
And did you hear the defendant say anything then?
Yeah. Just as I was rolling down the window, I heard Jamie scream, "I am going to kill him."
Miss Edwards, what day did you hear the defendant scream, "I am going to kill him"?
Same day as the funeral, April 28th.
And Miss Edwards, when was the last time you saw Eric Smith alive?
It was that very same day, April 28th, 2021.
Thank you. No further questions, Your Honor.
Thank you very much. Cross-examination at this time, counsel?
Yes, Your Honor. May I proceed?
Yes, whenever you're ready.
Good evening, Miss Edwards.
Good evening.
You were friends with Eric Smith, correct?
He wasn't the best person, but we were friends.
So even as a friend, you would say that he wasn't the easiest person to get along with, would you?
He wasn't a great person. He made a big enemy out of Jamie, after all.
But you would say that he's made enemies in town, plural, correct?
Jamie is the one I'm the most familiar with, but yes, he did have other enemies.
And you would even call Mr. Smith rude?
Yes, like when he was showing up to Jamie's mother's funeral unannounced and uninvited.
Objection, Your Honor. The witness is being non-responsive. My question asks for a yes or no.
Overruled.
Now, Miss Edwards, several hours after the funeral, you saw Mr. Cobey in his garden, correct?
Yeah, it was a weird time since snakes are active then.
Objection, Your Honor. Lack of personal knowledge as to snakes are more active at the time that she saw Mr. Cobey.
Sustained.
Motion to strike the everything after the yes.
And court will disregard everything after yes.
Now, Miss Edwards, Mr. Cobey seemed emotionally drained at the time, didn't he?
Objection, speculation.
Your Honor, if I may be heard?
Yes.
This is something that Miss Edwards would have been able to sense with her 5 senses. And additionally, if I may make an offer of proof, I will ask Miss Edwards if she heard Mr. Cobey say that he was exhausted.
All right, objections overruled.
Miss Edwards,
I'm sorry, why don't you ask the question one more time? Go ahead.
Mr. Cobey seemed emotionally drained at the time. Is that right?
Yeah.
He even told you he was exhausted?
Well, he did say he was exhausted and was going to be going to bed shortly, but he did say he had to do something important first.
Miss Edwards, yes or no, Mr. Cobey told you he was exhausted?
He did.
And you told Mr. Cobey that you were going to check up on him the next day, correct?
I did.
But Miss Edwards, nowhere in your witness statement do you mention ever going back to Mr. Cobey's home, do you?
I didn't go back, unfortunately.
Thank you, Miss Edwards. Your Honor, I have no further questions.
Thank you very much, counsel. Redirect examination at this time?
No, Your Honor.
All right, may this witness be excused, counsel?
Yes, Your Honor.
Yes, the answer is yes, I know. I'm sorry, I'm just treating this like it's my courtroom, okay? So you may be getting questions that you don't hear. So, all right, wonderful then. Let's move forward then. And with that, the prosecution may call their next witness.
Your Honor, the people call Angel Russell to the stand.
All right, and whenever your witness is ready, you may inquire.
Thank you, Your Honor. Your Honor, for the court's convenience, I will be referring to Exhibit E on page 56 of the case packet, and I'd like to request that the witness has this available to him.
Sorry, you'd like to request a witness what now?
Has this available to him, Your Honor.
All right, unless I hear otherwise, I'll assume the witness does have that available. The court is also looking at that at the same time. Thank you.
Thank you, Your Honor. May I proceed?
Yes, whenever you're ready.
Good evening, Mr. Russell.
Hi, good evening.
Mr. Russell, why are you here today?
I'm here to testify to what I witnessed on April 29th and April 30th.
We'll get to that in just a second. But first, Mr. Russell, what do you do for a living?
I work on power lines in Guernsey County.
Were you working on April 29th?
Yes, I got to work on the lines at Raptor Road just after 8:30 in the morning.
Did you see anything out of the ordinary that day?
Yes, I noticed someone come out of one of the houses and make their way towards the mailbox. They were carrying a wired cage that they kept looking down at and a bulky canvas bag.
Is that person here today?
Yes, the view I had made it clear that it was Jamie Cobey who was approaching the mailbox.
Objection, Your Honor. Lack of foundation as to how Mr. Russell identified Jamie Cobey.
May I be heard, Your Honor?
Yes.
If I could direct the court's attention to stipulation 10. Your Honor, stipulation 10 reads that Angel Russell can correctly identify the defendant.
That's my recollection too. Counsel,
Your
do you
Honor,
need to
may I
be
be heard?
Yes, I was going to say, you want to be heard further on that stipulation? Go ahead.
Yes, Your Honor. While it is stipulated that Mr. Russell can identify Jamie Cobey as that person, no foundation in this direct has been laid as to how Mr. Russell knew that at the time.
May I be heard, Your Honor?
Yes, ma'am.
Your Honor, we have established that the witness saw Mr. Cobey coming out of his house and walking around beneath him.
All right, the foundational objection is overruled at this time, and counsel, if you feel the need to, you can inquire on cross-examination further.
Yes, Your Honor.
May I proceed, Your Honor?
Yes, ma'am.
I'd like to direct the court's attention to Exhibit E. Mr. Russell, is Exhibit E a true and accurate representation of the cage you saw the defendant carrying?
Absolutely.
Objection, Your Honor. Lack of personal knowledge as to how Mr. Russell is aware that this is the same cage.
Oh, yeah, I'm going to sustain it. Lay a little foundation for us.
May I be heard, Your Honor?
Well, sure.
Your Honor, per the court's previous ruling that Mr. Russell was able to identify the defendant, this is the cage that the defendant was carrying, as we've laid foundation for, and therefore it's reasonable that the witness should be able to identify this cage as the one that he saw, just as he was able to identify the defendant.
Your Honor, may I be heard?
Yes.
Your Honor, it was stipulated that Angel Russell knew that Jamie Cobey was the person that he saw. It has not been stipulated that Angel Russell is in fact aware that this is the same cage that he saw, and therefore it still lacks foundation.
I'm going to sustain the objection, and you can ask some further follow-up foundational questions.
Thank you, Your Honor. Mr. Smith, did you see anyone else near the mailbox that day?
Yes, at around 12, I saw Mr. Smith approach the mailbox.
And what happened next?
Well, I turned and saw that he had reached his hand into the mailbox, and suddenly he started screaming. And when he pulled his hand out, this terrifying snake was completely latched onto his wrist.
Did you do anything to help him?
I did everything I thought I could have to help. I ran to my truck and got a breaker bar to kill the snake. I even tried sucking the venom out of his wound myself and urged him to see a doctor.
Mr. Russell, was it a rattlesnake that bit him?
Actually, yes. I noticed that it looked like a rattlesnake, but it didn't have a rattle, so I wasn't quite sure.
Objection, Your Honor. Speculation as to Angel Russell correctly identifying that snake as a rattlesnake.
Counsel, you want to be heard on that?
Yes, Your Honor. The witness's answer did not identify the rattlesnake as being a rattlesnake or not being a rattlesnake. The witness simply stated that while it looked like it could be a rattlesnake, it didn't have a rattle, and therefore he was not sure whether or not it was a rattlesnake.
All right, objection is overruled. I think it falls within just basic lay opinion. Go ahead.
What did Mr. Smith do after he was bitten?
He stood up and started screaming, Jamie.
Did you see
Objection,
Mr.
Your Honor. Hearsay.
Counsel, you want to be heard on that?
Yes, Your Honor. This falls under the excited utterance exception.
Your Honor, may I be heard?
Yes, sir.
Your Honor, according to the mock trial rules of evidence, excited utterance must either describe or explain the event as perceived by the declarant. The simple statement, Jamie, does nothing to describe or explain the event.
May I be heard, Your Honor?
Yes.
Your Honor, as this statement was made so shortly after Mr. Smith was bitten by a snake, it's a reasonable inference that in Mr. Smith's head, the word Jamie was somehow associated with this bite. Your Honor, it doesn't matter whether or not Mr. Smith was correct in his associations. To the court, it simply matters that he was somehow associating these two things together.
All right, the court's going to find that it is an excited utterance and also that it's not being offered for the truth of the matter, therefore is admissible. Go ahead.
Mr. Russell, would you like me to re-ask that question?
Yes, please.
Now, what did Mr. Smith do after he got bitten?
He stood up and started screaming, Jamie.
Did you see Mr. Smith again?
When I returned to work the next day, I saw Mr. Smith lying face down in the dirt in front of his own home. I thought maybe, just maybe, there was a chance he was still alive. But when I checked his pulse, there was nothing. I just wish I could have done more.
Mr. Russell, who was the last person you saw come near the mailbox before Mr. Smith was bitten by the snake inside?
Jamie Cobey.
And what was the defendant carrying when he approached the mailbox?
A wired cage and a bulky canvas bag.
Thank you, Mr. Russell. Your Honor, I have no further questions at this time.
Thank you very much. A cross-examination whenever you're ready, counsel.
Thank you, Your Honor. Good evening, Mr. Russell.
Hi, good evening.
On the morning of April 29th, you were working on some power lines over Raptor Road. Is that correct?
Yes, I was.
And these power lines were around 100 feet away from Mr. Smith's home?
That sounds about right.
Now, you saw Jamie Cobey walk towards those mailboxes, correct?
Yes, with the wired cage and bulky canvas bag.
Mr. Russell, you didn't see a snake in that cage, did you?
I don't remember what was in the cage.
So you don't remember seeing a snake?
I guess not, no.
Now, you noticed Mr. Cobey standing over mailbox 46601, correct?
I saw him standing next to the mailbox near Mr. Smith's home.
46601?
Yes.
You didn't see him touch the mailbox, did you?
No, I was working on the line, so I might have missed it.
You didn't see him open it either, did you?
But I only saw him next to it.
And so just to clarify, you didn't see him close the mailbox?
No, like I said, I only saw him next to it, and that's it.
Mr. Russell, you didn't see Jamie Cobey put a snake in the mailbox, did you?
No, I did not.
But you did see a snake bite Mr. Smith around 12 p.m., isn't that true?
And it was a horrifying sight.
You noticed some envelopes fall to the ground?
I did, yes.
Mr. Smith seemed to be in a sort of daze, didn't he?
Yes, and I panicked.
When you attempted to help Mr. Smith, he said he felt all right, didn't he?
He did, yes.
He even said that he didn't need a doctor?
Objection, Your Honor, relevance.
Your Honor, may be heard?
Yes, sir.
Your Honor, Mr. Smith's perception of this bite goes towards his the possible effects of the venom. And if I may make an offer of proof, Your Honor, later in this trial, the experts will contest, both Dr. Clay and Dr. Dunn, about the medical effects of the venom. Eric Smith's mental state and him correctly identifying whether or not he needed a doctor goes directly towards the culprits in this case and whether or not the snake bite definitively caused his death.
May I be heard, Your Honor?
Yes.
Your Honor, this is not a legal defense to first-degree murder and is therefore not relevant. The fact that Eric may have survived had he taken an antivenom or realized that he needed help is not a disputed fact in this case and has no tendency to prove or disprove whether the defendant committed an act.
Your Honor, may be heard?
Yes, go ahead. I'll give you the last say.
Your Honor, this piece of evidence doesn't go towards whether or not Jamie Cobey committed an act. Your Honor, it goes towards whether or not the natural and probable consequences of a snake bite would lead to the death of a person. Your Honor, if that is not the case, then that applies to the culprits in tonight's case.
All right. Anybody else want to be heard?
Yes, Your Honor.
All right.
Your
Go
Honor,
ahead.
CalCrim 520, murder with malice aforethought, does not have anything to do with whether or not the snake's venom would have been lethal enough to kill Mr. Smith. Your Honor, what is being disputed in this case is whether or not Jamie Cobey put the snake in the mailbox, whether or not he had a state of mind called malice aforethought, and whether or not he killed without lawful justification. Your Honor, that is CalCrim 520 for murder and has nothing to do with opposing counsel's argument in this case.
Your Honor, may I be heard one last time?
Oh boy, yeah, I tell you, I'm giving you a lot of leeway here to shine and score points. So go ahead, and then I got to make a rule and move on.
Yes, Your Honor. If I may direct the court's attention to the case packet, page 17, line 20. This is in CalCrim 520 regarding murder with malice aforethought. Your Honor, it states that in order to prove implied malice, point number 2 is that the natural and probable consequences of the act were dangerous to human life. This is exactly what we're trying to elicit right now.
Well, if you're trying to elicit what his reactions were to an alleged snake bite.
Yes, Your Honor. And
okay.
This will be testified to by both experts in this case. And the point of contention on whether or not this was a natural and probable cause goes directly towards this point in the culprits.
Versus it being caused by something completely unrelated to a snake bite.
Yes, Your Honor.
Such as
the pre-existing conditions that Eric Smith had, Your Honor.
All right, that's what I was looking for. Okay. The court is going to I can't remember who made the objections. The court's going to find it's relevant. Go ahead and move on.
Thank you, Your Honor. Mr. Russell, Mr. Smith said that he didn't need a doctor, did he?
He did say that, yes.
Thank you, Mr. Russell. Your Honor, I have no further questions.
All right, thank you very much. Redirect examination at this time, counsel?
No, Your Honor. May the witness be
All
excused.
right, then we'll excuse this witness at this time, and the people may call their next witness.
Your Honor, the people call Dr. Charlie Dunn to the stand. And for the court's convenience, I will be referring to Exhibit D on page 55 of the case packet.
All right, I have
let
it.
the witness have that in front of them.
Okay, no problem. Whenever your witness is ready, you may inquire.
May I proceed, Your Honor?
Yes, sir.
Good evening, doctor.
Good evening.
Could you tell the court a little bit about your educational background?
Yes, of course. I have my MD from the University of Central California with a specialization in clinical and forensic toxicology.
I also became familiar with venomous animals during med school.
And for those of us who aren't medical doctors, what is toxicology, doctor?
Yes. Toxicology is, simply put, the study of dangerous chemicals and their properties.
And what do you do today?
I have been Burnsley County's chief medical examiner for the past 6, almost 7 years now.
Thank you, doctor. Moving on, what's your role in this particular case?
I performed the initial autopsy of the victim in this case, Mr. Eric Smith, and as the resident medical examiner, I was also tasked with determining the official cause of death.
And doctor, what did you find in your autopsy?
Well, upon initial examination of the body, I noted that the victim had 2 swollen puncture wounds on his left wrist, indicative of a snake bite.
Doctor, I'd like to direct your attention to what's been previously marked as Exhibit D on page 55 of the case packet. Could you identify this exhibit for us, doctor?
Yes, this is the photograph that I took of the snake that bit Mr. Smith, to which I've determined to be a Mojave rattlesnake.
And is this a true and accurate representation of the photograph that you took, doctor?
It is, yes.
Doctor, Your Honor, the people would like to move Exhibit D into evidence.
Any objection from defense counsel?
No, Your Honor.
Then that exhibit shall be moved into evidence at this time. Thank you.
Doctor, you mentioned that the snake was a Mojave rattlesnake. Is this significant?
Definitely. Mojave rattlesnakes are special because they produce a venom that is 16 times more potent than any other rattlesnake species around.
And how did this snake's bite, if in any way, contribute to the victim's death?
Well, as the snake bit Mr. Smith, its fangs deposited venom containing special toxins called neurotoxins and hemotoxins into Mr. Smith's bloodstream.
Let's start with the hemotoxins. Could you explain how they work?
Hemotoxins attack red blood cells. You can think of them like sharp knives coursing through your veins, slowly destroying you from the inside out. It leads to severe damage to the blood and consequently the heart as well.
Okay, no problem. Hold on. I'll just ask all counsel, just wait to the end of either the question or the answer, and then I'll entertain any objection rather than interrupt, because that way I can at least get a full body of material that you're objecting to so I can make a better objection. So I'm sorry, counsel, was there an objection there to this answer to the question on describing the venom?
Yes, Your Honor. Unfair extrapolation to that very detailed and graphic description of how a hemotoxin would feel. This would unfairly increase the notion of how severe that venom is, which directly goes to the calcrims. And since it's not anywhere in the packet that is how a hemotoxin feels, it is an unfair extrapolation.
Your Honor, may I be heard?
Yes, sir.
Your Honor, the witness is a medical examiner, and as we have laid foundation, is highly qualified to testify to the effects of toxins. Therefore, it's a reasonable inference based on the facts in the case packet that the medical examiner would be able to testify and characterize the venom.
Well, let me ask you, counsel, not opposing counsel, defense counsel, is your objection to the hypothetical, or is it to the introduction of some type of analysis or opinion that can't be fairly extrapolated from the packet?
My objection is to the analysis of how severe the hemotoxin is. Again, Dr. Dunn gave a very graphic description, and this makes the hemotoxin seem more deadly than was originally intended for the case packet, which goes to unfairly affect the calcrims in tonight's case.
All right. Well, the court is going to find that it is close, but it is a fair extrapolation at this time, but it is close. So with that warning, so to speak, the objection is overruled.
Yes, Your Honor.
May I proceed, Your Honor?
Yes, sir.
Doctor, how did the hemotoxins affect Mr. Smith?
Well, as a matter of fact, in my autopsy, I found that Mr. Smith's heart had what's called epicardial hemorrhaging. This means that the membrane surrounding his heart was dangerously deteriorating and essentially bleeding out.
And doctor, if hemotoxins are like knives, what about the neurotoxins?
Well, if I may make another analogy, you know those pile-up car crashes on the freeway that completely stop the flow of traffic for miles? Neurotoxins actually act in a similar way, completely stopping the flow of sensory information from the body back to the brain. This neurological disconnect likely caused Mr. Smith to feel totally fine after he was bit, which is just another thing that makes this venom so deadly.
Doctor, you're saying that Mr. Smith likely felt fine after the bite. Why is that so dangerous?
Well, unfortunately, by the time Mr. Smith's brain would have even realized that the toxins were negatively affecting his body, it would have been much too late for him. With toxins like these at play, an antivenom would have had to have been administered immediately for any chance of survival.
Doctor, what happened to Mr. Smith's body as the venom took effect?
While the neurotoxins masked the symptoms, the hemotoxins could do their deadly work. After a long and agonizing 15 hours, Mr. Smith finally would have succumbed to the bite. It would have been a very slow and excruciatingly painful process.
Objection, Your Honor. Lack of personal knowledge to how the venom affected Eric Smith specifically.
Also, you want to be heard on that?
Yes, Your Honor. The medical examiner has done an autopsy on Eric Smith, and in addition, is an expert on the human body, including the nervous system. Therefore, this is within the witness's rationally based perceptions, as well as expertise, that they would be able to testify to how Eric Smith was likely feeling before he succumbed to his wounds.
Your Honor, may I be heard?
Yes.
Your Honor, this is still a lack of personal knowledge because Dr. Dunn isn't speaking to how venom generally affects the human body. She's speaking to specifically how it affected Eric Smith's body, which is a point that's in contention tonight.
Objection is sustained. Thank you.
Motion to strike that answer, Your Honor.
Answer shall be stricken. Disregard by the court.
Doctor, in your expert opinion, what caused Eric Smith's death?
I determined the final cause of death to have resulted from lethal envenomation. In my professional opinion, the snake bite was absolutely sufficient by itself to kill Mr. Smith. I come into contact with a lot of death in my career, but I have to say, death by venom is a special kind of brutal.
Thank you, Doctor. No further questions at this time, Your Honor.
All right, thank you. Cross-examination?
Yes, Your Honor. May I proceed?
Whenever you're ready, counsel.
Good evening, Dr. Dunn.
Good evening.
Doctor, it's rare to die from a rattlesnake bite, correct?
If the victim seeks antivenom, yes, it is rare.
That's right. In fact, because of this, only 5 of the approximately 8,000 annual bites result in a death.
Well, given that the rest of them tend to seek antivenom, I suppose that's true.
And throughout the 6 years you've worked in Burnsley County, you've only seen 3 deaths from a venomous bite. Do I have that right?
Yes, that is correct.
And only 1 of these were from a snake?
Yes, that is also correct.
Now, doctor, you concluded that Eric Smith's death was a direct result of the bite, correct?
Yes, and the introduction of fatal toxins to the body.
But doctor, you are aware that Mr. Smith did have pre-existing conditions.
Could you describe the pre-existing conditions that you're referring to?
Yes, the pre-existing kidney condition, which was in the case packet.
Yes, I believe that he had pre-existing kidney conditions as well as a myriad of cardiovascular issues. However, none of these would have contributed to his death alone. It is only due to the exacerbation by the introduction of toxins that Mr.
Objection,
Smith
Your Honor.
died.
Witness is being non-responsive. Move to strike everything after that, yes.
Sustained. Everything shall be stricken after, yes.
And doctor, you say yourself that a snake bite can exacerbate a pre-existing condition. Is that right?
Yes, however, the pre-existing condition did not kill Mr. Smith in this case.
Objection, Your Honor, non-responsive.
Oh, overruled as she answered as your question was phrased.
Now, Dr. Dunn, you agree that a snake can enter a mailbox on its own, correct?
I've personally found it to be quite rare.
But nonetheless, still possible?
Well, I suppose anything is possible.
And these spaces do include mailboxes, right?
Again, I found it to be quite rare in my personal knowledge.
But snakes are known to enter mailboxes. Is this true?
Objection, Your Honor. Calls for an improper expert opinion.
Overruled.
Dr. Dunn?
Could you please re-ask the question? Sorry.
Snakes are known to enter into mailboxes, right?
Again, it is quite rare.
But nonetheless, it has been known for a snake to enter a mailbox.
Again, anything is possible. So I suppose, yes.
And a snake's rattle can also come off naturally, can it?
Yet
Objection,
again,
Your Honor. Calls for speculation.
overruled based on her expertise. I think it's within the range of her expert opinion. Go ahead.
I have found it to be quite rare in my personal expertise.
Is that a yes, Dr. Dunn, that a snake's rattle can come off naturally?
Again, I suppose it is true.
And doctor, you weren't able to determine how this snake's rattle fell off. Is that correct?
Again, no, I'm not a qualified herpetologist.
Thank you, Dr. Dunn. No further questions, Your Honor.
Thank you very much, counsel. Any redirect examination at this time, counsel?
Yes, Your Honor.
Whenever you're ready, sir.
Doctor, to your knowledge, Eric Smith did not take antivenom after being bitten, isn't it?
No, he did not.
And given that decision, could Smith have survived the bite?
Absolutely not.
Thank you, doctor. No further questions.
All right, thank you very much. This witness may be excused at this time, and the people may call their next witness.
Your Honor, the people call Deputy Sheriff Toni Garrett to the stand.
All right, and as soon as your witness is settled in, you may inquire.
Good evening, Deputy Garrett. Could you briefly introduce yourself to the court?
Hello, I'm Toni Garrett, and I'm a Deputy Sheriff at the Burnsley Police Department.
As the Deputy Sheriff of Burnsley, how well do you know the people of this town?
Well, I've been working in Burnsley for almost 20 years now, so I pretty much know everyone.
Directing your attention to the death of Eric Smith, Sheriff Garrett, were you the lead investigating officer of this case?
Yes, ma'am, I was.
Can you walk us through how you began your investigation?
Of course. On April 30th, I responded to a call that an older man's body was reported to be found at 46601 Raptor Road.
And did you recognize this address?
Yes, I did. I recognized this as Eric Smith's address.
What did you do when you first arrived on the scene?
I conducted a visual examination at the victim's body, where I found puncture marks from a rattlesnake on his wrist.
And were you able to locate the rattlesnake?
Yes, I was. Mr. Russell, the witness who found the body, showed me what appeared to be a rattlesnake because of its fangs and markings, although I noticed there was no rattle on it.
And Deputy Garrett, did you examine anything else at the scene?
Yes, I examined a mailbox that was on Eric Smith's property.
Turning your attention to Exhibit B, is this a true and accurate representation of the mailbox that you saw?
Yes, it is.
Your Honor, the prosecution would like to request that Exhibit B be moved into evidence.
Any objection from defense counsel?
None, Your Honor.
All right, then People's Exhibit B shall be admitted into evidence at this time.
Thank you, Your Honor. Deputy Garrett, can you explain how you examined the mailbox?
Of course. So I gathered that the opening was 6 inches long and 1 3/4 inches wide, and I didn't see any visual fingerprints, so I dusted and lifted them off the mailbox and sent the report to forensics.
And while you waited for the report from forensics, did you interview any witnesses?
Yes, I interviewed many witnesses, including Dani Emling and Jamie Cobey.
Let's talk about your interview with Jamie Cobey. What did you learn?
Jamie said he knew nothing about Eric Smith's death and that he was at the mailbox to drop off his rent check.
His rent. And Deputy, can you describe the defendant's demeanor during the interview?
A minute. Yes, he appeared quite jittery and kept saying that he didn't know anything. And then he asked if we could stop the interview.
Deputy Garrett, have you ever spoken to Jamie Cobey before this?
Yes, I have. In fact, I've personally responded to half a dozen or so calls from Smith or Cobey, each complaining about the other.
Deputy Garrett, in your investigation, did you search the defendant's house?
Yes, I did.
And what did you find?
I found books on venomous snakes, a tub of rattlesnake rattles, and a bottle labeled anti-venom.
Objection, Your Honor. Hearsay as to the anti-venom label.
Counsel want to be heard?
Yes, Your Honor. Your Honor, this is not hearsay because there's no statement being made. There's no assertion of the truth being made either.
Is it being offered for the truth of the matter asserted or just as to what she observed?
Just as to what she observed, Your Honor.
All right. Counsel want to be heard on that argument?
Yes, Your Honor. We hold that this is being offered for the truth of the matter asserted, as access to anti-venom was a hard-hit point in previous examinations, so this is being offered for the truth of the matter asserted.
Your Honor, may I be heard?
Yes.
We are not asking the sheriff to testify as to what was inside the bottle was truly anti-venom. We are simply asking her what she found in her investigation.
All right, it'll be allowed in for the limited purposes of it was a label that said anti-venom, but not for the truth of the matter asserted that its contents may have contained such. Go ahead.
Yes, Your
Thank
Honor.
you, Your Honor. Sheriff, did you ever receive the report back from forensics?
Yes, I did.
And what did you find?
After receiving the report back from forensics, I learned that the fingerprints belonged to the victim and two of his tenants, Dani Emling and Jamie Cobey.
Sheriff, did you search the victim's house?
Yes, I did.
And when you searched the victim's house, did you find any of the aforementioned rent money?
1 minute. Yes, I found the rent money from all of Smith's tenants, except from Jamie Cobey.
And so, Deputy Garrett, after all of the evidence that you examined and recovered, what was the very last thing you did?
I arrested Jamie Cobey for the murder of Eric Smith.
Thank you. No further questions, Your Honor.
All right, thank you very much. Cross-examination at this time, counsel,
Yes, Your Honor. May I proceed?
whenever you're ready.
Good evening, Deputy.
Good evening.
You knew of Eric Smith the entire time that you worked in Burnsley, correct?
Yes, ma'am, for 20 years.
Now, you responded to one of Mr. Smith's calls saying that he suspected Mr. Cobey had broken into his home, didn't you?
Yes, ma'am.
But when you got there, you didn't find any evidence of a break-in, correct?
No, I didn't see any apparent evidence, ma'am.
Yet you gave Mr. Smith a state-of-the-art security camera from the police department anyway. Is that right?
Yes, I was helping a citizen of Burnsley.
And you even showed Mr. Smith how to set up this camera?
Yes, I put it on a pole facing his gate so he could see if anyone walked in.
Now, on April 30th, when you went to investigate Eric Smith's death, you saw the mailbox open, correct?
Yes, that is correct.
And it was empty as well?
Yes, ma'am, that's correct.
Now, on direct examination, you mentioned that you found rent payments in Mr. Smith's home. Just to be clear, these payments were checks, correct?
Yes, they were, and I did not find one from Jamie Cobey.
Again, Deputy, these were checks?
Yes, they were.
Now, you received a report from forensics regarding the fingerprints found on the mailbox. Is that right?
Yes, from the victim and two of his tenants, Dani Emling and Jamie Cobey.
And so Mr. Cobey's fingerprints weren't the only fingerprints found on that mailbox.
No, they were not.
Miss Dani Emling's fingerprints were on the front and the top of that mailbox, weren't they?
Yes, that is correct.
And at the moment, Deputy, there is no method to determine the precise time at which a fingerprint was left on a surface, is there?
Not that I'm aware of.
Yet you dismissed Miss Emling after just one interview?
Yes, that interview was the only interview necessary. I ruled her out as a suspect.
Thank you, Deputy. Your Honor, I have no further questions.
All right, any redirect examination at this time, people?
Yes, Your Honor.
Go ahead.
Deputy Garrett, what factors contributed to your decision to arrest Jamie Cobey?
A combination of everything I found in my investigation, witness testimony, physical evidence, and my expertise.
And did you deem this sufficient to make an arrest?
Absolutely.
Thank you. No further questions, Your Honor.
All right, thank you very much. At this time, it looks like then the people would rest. Is that correct?
Your Honor, the people do rest.
All right, then. Thank you very much. The people having rested at this time, then, is the defense may at this time call their first witness.
Yes, Your Honor. The defense calls Dr. Tyler Clay.
All right, and as soon as the doctor is settled in to the witness stand, you may inquire.
Good evening, Dr. Clay.
Good evening, Mr. Delpasan.
Could you please introduce yourself to the court?
Sure. My name is Dr. Tyler Clay, and I earned my bachelor's degree in science at Central State University, followed by a PhD in herpetology at the University of Central California. Previously, I've served as a resident naturalist at multiple national parks, but currently I'm the director of the Southland Zoological Museum.
And how are you involved in tonight's case?
I was tasked with investigating the medical examiner's report on the death of Eric Smith and the actual Mojave rattlesnake that bit Eric Smith.
Doctor, what do you know about the bite of the Mojave rattlesnake?
Well, the bites themselves rarely cause fatalities, as victims will typically seek out antivenom immediately. Now, the effects of these bites may worsen if the victim wastes time or has pre-existing and underlying health conditions. It's worth noting, Mr. Delpasan, that these pre-existing and underlying health conditions can be elevated to the point of lethality in the event of a snake bite.
Doctor, I understand you reviewed the autopsy of Eric Smith before tonight. What did you learn about the condition of his health?
I was informed of the victim's pre-existing kidney condition and congestive heart failure.
Objection, Your Honor. Improper expert opinion.
Ruled.
May I be heard, Your Honor?
Yes, I'll hold off on that ruling. Go ahead.
Your Honor, Dr. Tyler Clay is not a medical doctor, does not have a medical degree, and did not conduct the autopsy of Mr. Eric Smith. Therefore, opposing counsel has not laid sufficient foundation that it lies within their expertise to determine if Mr. Eric Smith did or did not have a pre-existing condition.
Anybody else want to be heard before the court rules?
Yes, Your Honor, if I may.
Go ahead.
Your Honor, Dr. Clay knows this information because he read the autopsy of Eric Smith and learned about the congestive heart failure and the information about a pre-existing kidney condition. It stipulated that Dr. Clay would have reasonable knowledge of facts inside the case packet that pertains to his testimony. This pre-existing kidney condition is one of them.
I'm not quite sure whether it's in the packet or stipulation, or it's just the court's going to find that it falls within the area of materials that an expert witness can rely on. But reading, looking at, and learning information from an autopsy report or any type of report that was utilized either by this witness or the opposing witness, the other doctor, is fair play for either one of these folks. So objection is overruled. Go ahead.
Yes, Your Honor. Doctor, you also mentioned that you examined the rattlesnake in tonight's case. What did you learn about the snake?
Well, I noticed that the rattlesnake bit the victim during the season of peak snake activity. The rattlesnake was inside a typical hiding place. The snake was missing its rattle, and the snake likely acted defensively after the victim reached into the mailbox.
Objection, Your Honor. Speculation as to this snake's specific behavior.
Counsel, want to be heard?
Yes, Your Honor. This is not speculation because Dr. Clay is not making a definitive conclusion, but rather speaking what is more likely based off of his expertise in herpetology and his years of experience in the field.
All right, objections overruled. Go ahead.
Dr. Clay, were you able to finish your answer?
No, Mr. Delpasand. I wanted to end it by saying, quite frankly, this is what I would describe as a worst case scenario for the victim in today's case.
Doctor, let's break that down. What do you mean by typical hiding place?
I'm sorry, typical what?
Typical hiding place, Your Honor.
Oh, okay. Sorry, I didn't hear that. Go ahead.
Well, during the day, rattlesnakes like to retreat inside dark places that are away from the sun, such as inside mailboxes. They do this because they wait to hunt for prey later in the day.
Now, turning to that second point, Doctor, are there any explanations for the missing rattle?
There are. It's both a common and natural occurrence.
Doctor, I want to talk to you about Dr. Charlie Dunn's examination of tonight's case. Are you aware of her conclusions?
I am, Mr. Delpasand, although ultimately I believe her conclusions are erroneous.
Well, why is that?
I believe this because it's common knowledge among desert residents that deliberately placing a rattlesnake inside a mailbox should only be attempted with bite-resistant gloves and tongs. But even then, Mr. Delpasand, this is still an inherently dangerous and difficult task to undertake.
Now, Doctor, based on your extensive experience with snakes and your examination of this snake specifically, what can you conclude about tonight's case?
It is my expert opinion that the snake's behavior in tonight's case was consistent with what is naturally observed. This, combined with the fact that deliberately placing a rattlesnake inside a mailbox is still a perilous gambit, even with the proper equipment that the defendant lacked, means it's extremely unlikely that the rattlesnake was deliberately placed inside the mailbox in tonight's case.
Objection, Your Honor. Speculation.
Counsel?
Your Honor, this is not speculation because Dr. Clay is not making a definitive conclusion on how the snake entered the mailbox, but rather is giving what would be the most likely scenario given the circumstances, which would be peak snake activity, the tools that Mr. Cobey had access to, as well as the commonality of snakes entering mailboxes on their own, which is something that Dr. Clay is qualified to testify about given his expertise in herpetology and his years of experience.
You don't think that goes to an ultimate fact that needs to be determined by the court?
Your Honor, Dr. Clay was testifying which scenario would be more likely. He wasn't making a definitive conclusion about this case.
All right, counsel, you want to be heard?
Yes, Your Honor. The doctor is implying that there is a definitive conclusion in this case. And if opposing counsel concedes that the doctor is not making a definitive conclusion, then the people are willing to let this testimony through.
All right, the objection is overruled. The court is not taking that testimony as to an ultimate fact, as to the ultimate cause, which this expert witness cannot opine, but as to more of a hypothetical and or likelihood or possibility. So the court will give it its appropriate weight. Go ahead.
Yes, Your Honor. And doctor, would you recommend moving a snake under any circumstances?
Not at all.
Your Honor, relevance.
Yes, counsel, what's the relevance?
Your Honor, this is relevant because if I may make an offer of proof, Dr. Clay will testify that it is common knowledge that snakes are very dangerous to be moved regardless of any circumstances, regardless of any equipment, which is relevant because it goes to the charges of the calcrims, whether any act was committed.
Maybe.
Well, but yes, go ahead, counsel.
Your Honor, whether or not it's typically dangerous to move a rattlesnake in a cage is not relevant to the disputed fact of whether Jamie Cobey did in fact move this rattlesnake.
What material fact makes this relevant, counsel?
Your Honor, the material fact that makes this relevant is that it is common knowledge among desert residents. Since Mr. Cobey is a desert resident himself and does have reasonable knowledge on snakes, it is more likely that he would know that moving a snake, regardless of any equipment, is a dangerous task, which goes to show the likelihood of whether he actually committed this act or not.
Boy, that's stretching the taffy pretty long there. So objection is sustained.
Yes, Your Honor. And Dr. Clay, is there any other experience we need to know about?
Objection, Your Honor, vague and ambiguous.
Your Honor, I may rephrase.
Sustained. Go ahead and rephrase the question.
Dr. Clay, is there any other experiences or educational background that you've had that we need to be aware of?
Mr. Delpasand, I've been bitten twice by a rattlesnake, and I'm a desert resident myself, among all of my other field experience as a resident naturalist and zoologist.
Thank you, Dr. Clay. No further questions, Your Honor.
All right, thank you. Cross-examination?
Yes, Your Honor. May I proceed?
Yes, sir, whenever you're ready.
Good evening, Doctor.
Good evening, and your name is Mr. Eisenberg, is that correct?
That is correct, Doctor. Doctor, a snake bit Eric Smith, correct?
That's my understanding.
And that snake was a Mojave rattlesnake, correct?
As far as I'm aware.
Now, Doctor, by your own definition, the Mojave rattlesnake is easily the most venomous snake in North America, correct?
The most venomous snake native to North America.
Is that a yes to my question, Doctor?
With that qualifier.
Thank you, Doctor. And Doctor, you would agree that victims of this snake's bite need antivenom immediately, correct?
If they want to avoid becoming a victim of this snake, certainly.
And Doctor, to your knowledge, Eric Smith did not take antivenom after being bitten, correct?
He did not seek out antivenom anywhere near promptly enough.
Doctor, I'd like to move on to the snake's position in the mailbox. You've had a chance to review the other witness statements, correct?
That would be correct.
And on direct, you've testified that it's possible for snakes to squeeze into small spaces, correct?
Not only is it possible, but it's naturally observed.
I'd like to move on from these possibilities and move on to some of the facts of the case, Doctor. Doctor, Jamie Cobey was seen near Eric Smith's mailbox the morning of the bite, correct?
I believe that to be correct.
And the defendant's fingerprints were found on the mailbox, true?
Objection,
Among others.
Relevance.
Okay, counsel, relevance here?
If I may make an offer of proof, Your Honor.
Yes, sir.
I will be asking the doctor about his recommendations on the most efficient and recommended ways to handle snakes. And this will line up with the testimony of what's happened in this case with Jamie Cobey walking toward the mailbox.
All right. Anything further from counsel?
Yes, Your Honor. This is not relevant to Dr. Clay specifically. This doesn't have to do with his area of the case. He's here to testify about the snake's behavior and the effects of snake venom, not other aspects of this case.
Counsel, would you concur with that?
Your Honor, the doctor is here to testify of his expertise on snake behavior and snake recommendations. And my questions about Jamie Cobey's behavior the morning of the bite are directly relevant to this, as Jamie Cobey was carrying a humane animal trap that same morning.
Court's is not going to find that it's relevant to a material fact, therefore the objection is sustained.
Doctor, Jamie Cobey owns several snake handling tools, correct?
Jamie Cobey, possessed the tools typical of a resident naturalist.
Is that a yes to my question, Doctor?
Certainly.
And one of these tools was a humane animal trap. Isn't that true?
It's one of the tools typical of the trade.
Now, Doctor, Angel Russell has testified that that morning Jamie Cobey was seen walking toward the mailbox. He was carrying both a canvas bag and a humane animal trap, correct?
I believe so.
And Doctor, you recommend a humane animal trap when transporting venomous snakes, correct?
If one were to take on a task as dangerous as moving a Mojave rattlesnake, I would recommend a snake cage, among other items.
Thank you, Doctor. No further questions.
Redirect examination.
Briefly, Your Honor, may I proceed?
Whenever you're ready, counsel.
Doctor, what equipment specifically would you recommend to even consider moving a rattlesnake?
I would recommend a humane animal trap, bite-resistant gloves, and tongs of sufficient length.
Now, doctor, were any snake tongs found in this case?
As far as I'm aware, they were not, Mr. Delphison.
Thank you, Dr. Clay. No further questions, Your Honor.
All right, thank you very much. This witness may be excused, and counsel, you may call your next witness.
Yes, Your Honor. The defense calls Francis Yazzie.
And once your witness is settled in, you may inquire.
Yes, Your Honor. Good evening, Mr. Yazzie.
Good evening.
Could you please introduce yourself to the court?
Sure. My name is Francis Yazzie, but I also go by Yazzie the Creator. I'm passionate about art and a connoisseur of agaves, a miracle of nature, what I like to call the Mexican tree of life. I even used to own my own restaurant where I sold the most suave agaves in town.
Mr. Yazzie, did you meet anyone at your restaurant who stood out to you?
Objection, vague and ambiguous.
You understand the question, Mr. Yazzie?
Yes, I do.
All right, overruled. Go ahead.
Yes, I did, actually. I met Jamie Cobey.
And why did he stand out?
Besides his immense passion for agaves, he was such a kind, creative, and gentle soul. I noticed he was frequently gardening for his fellow neighbors, and he even taught me how to take care of my own precious succulents, all for free. He's a man of nature.
Any other reasons, Mr. Yazzie?
Yes, actually. He spent most of his days taking care of his mother before she unfortunately passed away. May she rest in paradise.
Mr. Yazzie, what did you notice about Mr. Cobey's behavior after his mother passed?
So on the afternoon of his mother's funeral, he did seem rather agitated, which I get based on the argument.
Speculation.
Tell you what, let me hear the question again. Let me hear the full answer, and then I'll entertain the objection, okay? Go ahead, ask the question over again, please.
Mr. Yazzie, what did you notice about Mr. Cobey's behavior after his mother passed?
So on the afternoon of his mother's funeral, he did seem rather agitated, which I get based on the argument he had with Eric Smith, his landlord.
All right, I'll entertain the objection now if you have it.
Speculation, Your Honor, as to agitated.
All right, the court's going to sustain the objection as to the latter part of that question, keep the first part in. I don't have a real time here, so I can't tell you exactly what the words are, but it encompasses the court's ruling on that. Go ahead.
Yes, Your Honor. Mr. Cobey, did you notice any change in his behavior after the funeral?
Yeah, although he was still hurt that his mother just passed away, he calmed down and got over the argument within just an hour. He even went on a laugh about it, saying how Eric is just being Eric.
Thank you, Mr. Yazzie. Your Honor, I have no further questions.
Thank you very much, counsel. Cross-examination at this time?
Yes, Your Honor. May I proceed?
Yes, whenever you're ready.
Good evening, Mr. Yazzie.
Good evening. How are you today?
Well, thank you. You have been good friends with the defendant for 10 years, correct?
Yeah, that's how I know him so well.
And the defendant would frequently visit you in the evenings, right?
Yeah, he came over often.
And he would even do your gardening work for free, correct?
Yeah, he taught me how to take care of my succulents.
In fact, you even talked about going into business together once the pandemic ended, correct?
We had an idea or two.
On the other hand, you didn't like Eric Smith very much, did you?
I wouldn't say I was his biggest fan.
In fact, you would call Eric Smith a jerk, correct?
Yeah, he wasn't that nice.
And you believe that Eric Smith made your good friend, Jamie Cobey's life miserable, right?
That is true, correct.
So, Mr. Yazzie, you are here today testifying on behalf of your good friend, Jamie Cobey, correct?
Yes, that is correct.
But let's be very clear, Mr. Yazzie, you were not with the defendant the morning of April 29th, were you?
No, I was not.
And you were not with the defendant when he went to the victim's mailbox?
No, I was not.
And so you cannot tell us definitively whether or not Jamie Cobey put a snake inside the victim's mailbox, correct?
Objection, Your Honor. Argumentative.
I'm sorry, the question again, it cut out for a second there. What was the question again?
Mr. Yazzie cannot tell us whether or not Jamie Cobey put a snake inside the victim's mailbox.
Okay, overruled on those grounds.
Yes, Your Honor.
But Mr. Yazzie, you were with the defendant the previous evening, correct?
Yeah, I was with him the previous evening. That is correct.
And that evening, the defendant seemed to be in an agitated state, correct?
Objection, Your Honor. Calls for speculation.
Overruled. You may answer.
Yeah, but he calmed down within an hour.
But on that very same evening, the defendant had an argument with the victim. Isn't that right?
That is true. On that evening, he did have an argument, but he calmed down.
Thank you. No further questions, Your Honor.
All right, redirect examination.
No redirect, Your Honor. May this witness be excused?
Yes, thank you very much. And defense counsel may call our next witness.
Your Honor, the defense calls Dani Emling.
And whenever your witness is ready, you may inquire.
Thank you, Your Honor. Good evening, Miss Emling.
Good evening.
Could you tell us a little about yourself?
Sure. My name is Dani Emling, and I run Emling's Emporium, the #1 convenience store down in Burnsley. Living in the desert's pretty cool. There's nothing like a Burnsley sunset.
Miss Emling, do you know Jamie Cobey?
Yes, I do.
How do you know him?
Jamie is one of my neighbors, and he actually helped me beautify my drought-tolerant garden. He's a great guy, loves nature and animals.
Miss Emling, you mentioned that you're neighbors with Jamie Cobey. Where do you live?
We both live on one of Eric Smith's properties on Raptor Road.
And what was Mr. Smith like as a landlord?
I don't like to speak ill of the dead, but Eric was rude and a bad landlord. I've seen him get into a lot of fights with his tenants, including myself.
And what were your fights with Mr. Smith about?
Eric would sometimes shut off the utilities when rent was only a day late, and he took forever to do simple repairs. He also blasted this really loud heavy metal music at all hours of the morning.
Miss Emling, did you ever witness any fights between Mr. Cobey and Mr. Smith?
Yes, I did see them argue a couple of times.
When was the last time you saw the two of them together?
Well, surprisingly, it was at Jamie's mom's funeral. May she rest in paradise.
Miss Emling, why was that surprising?
I couldn't believe Eric showed up, especially with how he treated Jamie's mom. It was despicable.
Miss Emling, what did you do after the funeral?
Right after I dropped my rent in Eric's mailbox, I left town for a couple of weeks.
And was there any reason for you to touch that mailbox?
I don't open it or anything. I only use the slot at the top to put my rent in.
Thank you, Miss Emily. Your Honor, I have no further questions.
Thank you very much, counsel. Cross-examination, counsel, whenever you're ready.
Yes, Your Honor. May I proceed?
Yes, go ahead, ma'am.
Good evening, Miss Emling.
Good evening, Miss Kay.
You've hired the defendant to help you with your yard before, right?
Yes, he's great at gardening work.
You thought he did a beautiful job, right?
The colors were so vibrant. Yes.
And you're also a neighbor of the defendant's, true?
Yes, that's correct.
And isn't it true that the defendant would complain to you about Mr. Smith?
Yes, he would rant to me.
And you said you knew the feeling.
Absolutely. Eric's so annoying.
Objection, Your Honor, non-responsive as to everything after absolutely.
Overruled at this time.
You were even invited to the defendant's mother's funeral, Miss Emling.
Yes, that's correct.
And you were also a tenant of Eric Smith's?
Yes.
And you thought he was a terrible person, right?
Absolutely. He was a terrible person.
But you would agree that you two didn't fight too often, right?
Not too often, but all the tenants had their fights.
On the other hand, you witnessed many fights between Mr. Smith and the defendant, correct?
Objection, Your Honor. Vague and ambiguous as to many fights.
Overruled.
Miss Emling, would you like me to repeat the question?
Yes, please.
On the other hand, you witnessed many fights between Mr. Smith and the defendant, correct?
I did see them fighting sometimes.
Is that a yes to my question, Miss Emling?
Yes.
And these fights were so bad that even the sheriff was involved. Isn't that true?
When Jamie would get annoyed, he would call the sheriff.
Is that a yes to my question, Miss Emling?
Yes, that was his way of dealing with it.
And in your own words, Eric killed Jamie's mother.
In my opinion, sure, yeah.
Thank you, Miss Emling. No further questions, Your Honor.
Thank you very much, counsel. Redirect to examination, counsel.
Yes, Your Honor. May I proceed?
Whenever you're ready, sir.
Thank you. Ms. Emling, you mentioned on cross that Mr. Smith and Mr. Cobey occasionally had arguments with each other. What did Mr. Cobey usually do after these fights?
From what I saw, Jamie would cool down really quickly, and I even saw him apologize several times.
Objection, Your Honor. Speculation as to that he would cool down really quickly.
Your Honor, may I be heard?
Well, sure. Go ahead.
Your Honor, Ms. Emling can view with her five senses Jamie Cobey cooling down in terms of his temperament. And like she just said, she saw Mr. Cobey apologize many times after arguments.
I think
May I be
that's
heard, Your Honor?
Sure, of course.
Your Honor, while the witness may have seen Mr. Cobey apologizing after arguments, she cannot make the inference that this was because he had cooled down. Your Honor, she does not have the personal knowledge to say definitively that he did always cool down after these fights, and therefore this question calls for this witness to speculate.
Well, I think the court's interpreting it as her observations as to the fights that she observed, that she saw him cool down, and whether that's a character trait that goes on to all of his fights is to be seen. So the court's going to find it falls within acceptable lay opinion. I think it's then overruled, if I recall. Thank you.
Thank you, Your Honor.
Ms. Emling, were you finished with your answer?
Yes, I was just saying I saw him cool down really quickly, and I saw him apologize several times.
Thank you, Ms. Emling. Your Honor, I have no further questions. May this
All
witness
right.
be excused?
Yes, thank you very much. At this time, the defense may call their last witness.
The defense calls Jamie Cobey.
All right. And as soon as Mr. Cobey is ready, you may proceed.
Yes, Your Honor. Good evening, Mr. Cobey.
Good evening.
Could you tell the court a little bit about yourself?
I'm Jamie Cobey. I'm from Burnsley County. Since I'm kind of a nature nerd, I like to xeriscape garden, which is gardening with very little water.
And what kind of equipment does xeriscape gardening require?
Well, normal gardening tools, but I also have a lot of protective equipment because there are venomous animals like snakes and scorpions. So I have long sleeve gloves, high boots, and a humane animal trap so I can release animals back into the desert.
And other than your gardening, have you done any other work recently?
I used to work at Blue Agave, but due to COVID, I lost my job.
So how did the pandemic affect your financial situation?
I couldn't find much work, but I was able to make it through with the help of unemployment checks and my mother's state disability check.
Well, why did your mother qualify for a state disability check?
My mother had a chronic respiratory disorder, And when I lost my job, I spent a lot of time helping her, which was especially difficult during a pandemic and everything that was going on with Eric, my landlord.
How would you describe your relationship with Mr. Smith?
We had a rocky relationship, and after the pandemic started, things seemed to get even worse with him.
And how did the pandemic make things worse?
Now, I felt for him because he had a pre-existing health condition just like my mom. But when the eviction moratorium was put in place, he called it a curse. I tried to pay the rent when I could, but times were tough, and he started randomly turning off the power, which endangered my mom.
And why did shutting off the power endanger your mom?
For her condition, she required an oxygen tank, and without it, she died.
Mr. Cobey, if I could ask, how exactly did your mother die?
On April 22nd, Eric shut the power off again, and I was outside gardening, so I couldn't hear her as she called for help while she was having a heart attack.
Was she able to get medical attention?
The nearest hospital is 45 minutes away. I tried to get her there, but I was just too late.
Now, did you see Mr. Smith after your mother's death?
Yes, I saw him at her funeral.
And how did you react upon seeing him?
I lost my temper, and I said some things I regret, but I don't blame him entirely for my mom's death.
Do you blame anybody?
Not really. She was very ill, so naturally, it was only a matter of time.
So what did you do immediately following your mother's funeral?
2 minutes.
I went to my friend's house just to wind down, and then I went home. But there were just all these snails in my garden, and I guess after a long day, I got frustrated, and I said I was going to kill them. Obviously, I didn't mean it. I'd never kill a living thing.
And did your mother's death impact your gardening work at all?
Yes, actually, later that week, I had to sell my gardening tools to cover the funeral expenses.
Did you continue to be a tenant of Mr. Smith's?
Yes, on the 29th, I dropped off cash in his mailbox to pay part of my rent.
Lastly, Mr. Cobey, did you put a snake in Mr. Smith's mailbox?
No. I mean, I didn't really agree with the way he did things, but I would never wish anything bad on an ill man.
Objection, Your Honor. Witness is launched into a narrative.
Overruled. Looks like you just finished up. Go ahead.
Thank you. Mr. Cobey, Your Honor, I have no further questions.
Thank you very much. Counsel, cross-examination?
Yes, Your Honor. Before I begin, I'd like to inquire as to the time remaining for cross-examination for the prosecution.
The prosecution has 4 minutes and 15 seconds remaining for cross-examination, and the defense has 1 minute and 2 seconds remaining for redirect.
Thank you.
May I proceed, Your Honor?
Yes, counsel.
Mr. Cobey, you are very familiar with the different species of snakes in the area, right?
Yes, as a gardener, I am.
And yes or no, you owned an animal trap.
Yeah, to release animals back into the desert.
Objection, Your Honor, non-responsive. Motion to strike testimony after yeah.
Overruled at this point.
But Mr. Cobey, you no longer own this animal trap.
No, I had to sell it.
You sold it on April 30th, correct?
Yes, to cover the funeral expenses.
And in your opinion, you sold it for too cheap, right?
Unfortunately, yes.
Let's move on to your relationship with Mr. Smith. You believe Mr. Smith was a bad landlord, right?
Yes.
You did not like him, true?
Not particularly, no.
And on April 22nd, he shut off your electricity, correct?
Yes, again.
This caused your mother's oxygen machine to shut off?
It did.
And she died that same day, didn't she?
Yeah, she did.
And even after all that, Eric Smith showed up at your mother's funeral. Isn't that true?
Yes, he did.
And this was on April 28th?
I believe so, yes.
And Mr. Smith showing up at your mother's funeral made you angry.
Yes, I lost my temper.
When you lost your temper, You accused Mr. Smith of killing your mother.
Yes, but I don't blame him entirely for my mom's death.
Objection, Your Honor. Witness has become non-responsive.
Overruled. Go ahead.
Mr. Cobey, you've called the police on Mr. Smith before, right?
Yes, after arguments.
You've called them several times, correct?
Yes.
But when your mother died, you didn't call the police.
No, it was more grieving.
But what you did do was go to his mailbox the next day, correct?
Yes, to pay part of my rent.
You brought your animal trap with you to pay part of your rent, correct?
Yes, as a gardener, I have my tools.
The same trap you used to relocate the snakes from your garden, correct?
Yes, to release them humanely.
And after you went to Mr. Smith's mailbox that day, you never saw him alive again.
No.
Thank you. No further questions.
Minutes remain.
You counsel redirect examination?
Yes, Your Honor. May I proceed?
Whenever you're ready, counsel.
Mr. Cobey, do you blame anybody for your mother's death?
No, it was only a matter of time.
Objection, Your Honor. Unfair extrapolation as to the witness not blaming anyone for his mother's death.
Well, guide me to the factual pattern here to bolster your objection.
Yes, Your Honor. Your Honor, page 42, lines 31 to 33 of the witness's statement read, "But I did not blame Eric entirely for my mother's death. She had been very ill and I was extremely sad to lose her."
I see that. And you're saying his answer, which was?
Your Honor, the witness testified that he did not blame anyone at all for his mother's death. But Your Honor, in his statement, the witness says that he didn't blame Eric entirely for his mother's death, which does imply a partial blame.
Your Honor, if I may be heard.
Yes.
Mr. Cobey's answer was no, it was only a matter of time, which is in line with what he says here in that he doesn't entirely blame Mr. Smith for his mom's death and that she'd been very ill and he was very sad to lose her. His answer is in line with what his witness statement says.
The court's going to find that it's a fair, reasonable inference or extrapolation at this time, so the objection is overruled. Go ahead.
Mr. Cobey, were you finished with your answer?
Yes.
Now, opposing counsel brought up the funeral on cross-examination. Did you mean the things that you said at the funeral?
No, I was just grieving. I'm not proud of the things I said, but I didn't mean any of it.
And why did you have your humane animal trap with you when you went to put your money into the mail?
30 seconds.
I'm a gardener. It's part of my job to have the right equipment on hand.
Objection, Your Honor. Unfair extrapolation.
Which part is unfair?
Your Honor, nowhere in the witness's statement does it explain why he had this trap with him.
Counsel, what are your thoughts on that one?
Your Honor, as Mr. Cobey is a gardener and it's his job as a gardener, it's a fair extrapolation for Mr. Cobey to say that he would have his tools around him as he does his job.
May I be heard, Your Honor?
Yes.
At the time, the witnesses testified that he was dropping off a rent check, not gardening. Your Honor, while the witness does say that he has these tools for being a gardener, it's been established that at this time he was not gardening. And Your Honor, there's no explanation in the witness's statement as to why he had these tools on him in this specific instance. And therefore, this is an unfair extrapolation.
All right, I'll give counsel last word and then I'll make a ruling.
Yes, Your Honor. Mr. Cobey notes in his witness statement that he has done gardening work for other witnesses, including Miss Emling and Miss Yazzie, who live near him. So it'd be a fair extrapolation for him to say that as he gardens in his community, it would be reasonable for him to drop off a rent check on his way to do his work.
I think no, because I'm going to rule here, so I got to say no at some point. Sorry, I don't mean to deny either one of you for showing off how great you argue and stuff, but at some point we got to move along. The court is based on what the court has heard from both counsel as far as arguing this objection. The court is going to find that it is an unfair extrapolation. So go ahead and ask your next question.
Yes, Your Honor. Mr. Cobey, why did you sell your gardening tools?
To cover the funeral expenses.
Thank you, Mr. Cobey. Your Honor, I have no further questions.
All right, thank you very much. Will that conclude the defense case then at this time?
Yes, Your Honor. At this time, the defense rests.
All right, then let's move on to the next phase then. If everybody, why don't we just take a quick stretch and let's move into closing arguments if we can at this time. Is the prosecution ready and would they like to give their closing argument at this time?
Yes, Your Honor.
All right, then. Counsel, whenever you're ready, we'll hear your closing argument.
Thank you, Your Honor. There's nothing more dangerous than a person who has nothing to lose. And tonight, you've heard that the defendant, Jamie Cobey, lost everything. His job, his mother, his dignity. Yes, Jamie Cobey is a man who lost everything. And that, Your Honor, is exactly what made him dangerous. Now, you've heard the defendant lived a difficult life, living paycheck to paycheck, taking care of his mother in a small desert house. You've also heard the defendant had a landlord, Mr. Eric Smith. Police complaints, reports of harassment, and threats of eviction were the basic essentials of their relationship. But things finally came to a head when Eric Smith shut off the power to Cobey's mother's oxygen machine, directly resulting in her death. Ultimately, though, Your Honor, this isn't a case about what the victim did to the defendant, but about how the defendant then took revenge. Your Honor, the people have proven tonight, beyond a reasonable doubt, that Jamie Cobey is responsible for the murder of Eric Smith. The court has instructed that in order to prove this, the people must prove that the defendant planned and committed an act resulting in Eric Smith's death. We must also prove that the defendant acted with malice aforethought or a clear intention to kill. Finally, Your Honor, we must prove that the defendant acted with willfulness, deliberation, and premeditation. And tonight, the evidence has done just that. Now, you've heard of the long-standing feud between Eric Smith and the defendant, a drawn-out conflict that built up a powerful resentment in the defendant. But the defendant's murderous intent or motive really didn't crystallize until one distinct point, the funeral of Jamie Cobey's mother. Your Honor, you've heard that at this funeral, Eric Smith showed up unannounced. And you've heard that Jamie Cobey told Eric Smith, "You killed my mother." Your Honor, Jamie Cobey clearly blamed Eric Smith for his mother's death. In addition, you've heard two more statements from Terry Edwards made by the defendant. "I'm finally going to do it. And later, I'm gonna kill him." Your Honor, this goes to element 2 of Calcrum 520. The defendant harbored malice aforethought or a clear intention to kill. Now, in addition to motive, the defendant held the means and the opportunity to commit this murder, Your Honor. It's no coincidence that, as Dr. Charlie Dunn has testified, Eric Smith was bitten and killed by a deadly Mojave rattler. Cobey took a special interest in snakes and would have known the dangers the Mojave rattlesnake possessed. Cobey owned several snake handling tools, including a humane animal trap the ideal size for transporting the Mojave rattlesnake. And Jamie Cobey was there at the scene of the murder. Angel Russell has testified that the morning of the bite, Jamie Cobey walked toward Eric Smith's mailbox, holding a bag of tools and his humane animal trap. Now, the defendant simply claims they were there to drop off a rent check.
2 minutes.
But Your Honor, as Deputy Garrett has testified, no such check was ever found. That check doesn't exist, Your Honor. It's a fiction created by the defendant to cover their tracks, just like the fiction that when Jamie Cobey sold off his snake tools for too cheap directly following Eric Smith's death, it was to cover funeral expenses. Your Honor, the evidence clearly shows willfulness and premeditation. Now, you may believe that even though Jamie Cobey killed Eric Smith, it was a crime done in the heat of passion and therefore would constitute voluntary manslaughter. But the evidence shows that this is simply not the case, Your Honor. Francis Yazzie has testified that between the funeral and the murder, Jamie Cobey had plenty of time to cool down. Between these 2 points, the defendant had the chance to weigh all of the options, to make a decision, and to craft a plan. This was no sudden lapse of judgment, Your Honor, but a cold, reptilian resolve.
1 minute.
Now let's consider the burden of proof. Jamie Cobey held a motive shared by nobody else, his mother's killing. Jamie Cobey held the knowledge of snakes necessary to commit the murder, and the tools as well, a humane animal trap, anti-venom, bite-resistant gloves, and so forth. And Your Honor, Jamie Cobey was there at the scene of the murder. Your Honor, Eric Smith took the defendant's money, he took the defendant's pride, and he took the defendant's
30 seconds.
mother. Your Honor, in the end, Jamie Cobey was a man who had nothing left to lose, leaving him as dangerous as that rattlesnake that had no rattle. But Your Honor, Jamie Cobey can no longer run from the reach of law. Eric Smith may have underestimated the defendant, but we won't. And we ask that you don't either. Justice demands that you find the defendant guilty of murder in the first degree. Thank you.
Thank you very much, counsel. Defense, would you like to give your closing statement at this time?
Yes, Your Honor. May I proceed?
Whenever you're ready, counsel, of course.
The people ignored nature, both the nature of the desert and the nature of Jamie Cobey. Because in the Burnsley County desert, Eric Smith's death could have easily been a natural occurrence. But regardless, the people still called on Dr. Charlie Dunn, who admitted tonight that she's not even completely qualified to talk about snakes because she's not a herpetologist. Instead, she explained her theory of the effects of the snake venom. But the most important question, Your Honor, is how the snake got into the mailbox to begin with. Because if the people cannot prove beyond a reasonable doubt that Mr. Cobey placed that snake in Mr. Smith's mailbox, they cannot prove his guilt at all. And tonight we heard from herpetologist Dr. Tyler Clay that the people's alleged method of moving a snake into the mailbox is unreasonable, as it is far too risky. Certainly not a method Mr. Cobey, with all of his knowledge of snakes, would choose. Despite this, the people still turned to Angel Russell to create their false narrative that Mr. Cobey used a wired cage to move a snake into Mr. Smith's mailbox. But Your Honor, this narrative is riddled with reasonable doubt, because tonight Mr. Russell admitted that he wasn't even sure whether Mr. Cobey was holding a wired cage, let alone one with a snake. He also had to admit tonight that he never saw Mr. Cobey open, close, or even touch the mailbox. Your Honor, tonight the people have gone on and on about history of animosity, malice aforethought, premeditation, but they failed to prove the most basic element of Calcrim 520, whether Mr. Cobey even committed the act he's being accused of to begin with. And since they cannot prove even the first element of the charges, Your Honor, they have no case. But this didn't stop them from calling on Deputy Toni Garrett, the investigator who, after finding no evidence of Mr. Cobey entering Mr. Smith's home, still equipped Mr. Smith with a state-of-the-art security camera to keep tabs on Mr. Cobey. And tonight we learned that her investigation was incomplete because she claims that not finding a check from Mr. Cobey in Mr. Smith's home was evidence of guilt. But Your Honor, of course she didn't find a check because Mr. Cobey pays in cash. But she and the people ignored that as well. But then came Deputy Garrett's biggest error, her sole fixation on Mr. Cobey. Your Honor, as you heard tonight, Dani Emling was another suspect in tonight's case. She also had her fingerprints on the mailbox. She also had her issues with Mr. Smith. But Deputy Garrett dismissed her after just one interview. Instead, she pursued Mr. Cobey as her one and only suspect. Your Honor, for Deputy Garrett, my client's fingerprints were cause for suspicion, but Dani Emling was quickly dismissed. Your Honor, Deputy Garrett knew of alternative explanations, but still pursued only my client regardless, leading to nothing but reasonable doubt. But Your Honor, even after all we just talked about, we haven't even begun to address the people's most egregious oversight, the nature of Jamie Cobey. Your Honor, if there's one thing we learned tonight, it's that Mr. Cobey, above all, cherishes life. Tonight, we heard from Ms. Emling and Francis Yazzie that he was always taking care of his sick mother, that he values the life of animals and took hours out of his day to garden for his neighbors. Even in the hours leading up to the death of his landlord and neighbor, Eric Smith.
2 minutes.
He was spotted gardening peacefully by Terry Edwards. And after willfully disregarding alternative explanations, the people still want you to ignore Mr. Cobey's nature. But tonight we learned that Mr. Cobey always cooled off after his arguments with Mr. Smith. We learned from Miss Edwards that after the funeral, he wasn't angry. He was just tired. because Mr. Smith didn't have a reputation of being rude to Mr. Cobey. He had a reputation of being rude to everyone. Rude to people like Dani Emling, rude to people like Miss Edwards, two witnesses who testified tonight that Mr. Smith had made many enemies in Burnsley County, not just one. But still, the people fixate so much on the funeral to try to prove Mr. Cobey's guilt. But at the funeral, Mr. Smith wasn't saying or doing anything that Mr. Cobey did not already expect. This is how he felt after his mother's funeral when he told Mr. Yazzie that Eric was just being Eric. Your Honor, Calcrum 224 states that if the court can draw two or more reasonable conclusions from the evidence, with one pointing to guilt and the other pointing to innocence, the court must accept the conclusion that points to innocence. And tonight, the people were not able to prove Mr. Cobey's guilt beyond a reasonable doubt. The people might have ignored nature tonight, Your Honor, but the court must not. And the nature of tonight's case points to only one verdict, and that's finding Mr. Cobey not guilty on all counts. Thank you.
Thank you very much, counsel. Is prosecution ready for a rebuttal argument at this time?
Your Honor, we're ready.
Whenever you're ready, sir, go ahead.
Your Honor, the defense's explanation of Eric Smith's death may be natural, but it is not reasonable. And in the case of circumstantial evidence, Calcrum 224 states that you must reject all conclusions that are unreasonable and only accept those that are reasonable. Although the defense relies on highly unnatural assertions of Jamie Cobey's character, they cannot dispute the facts of the case. Jamie Cobey and no one else held a reasonable motive for murder.
30 seconds.
Jamie Cobey held the tools necessary to commit the murder. Jamie Cobey was at the site of the murder, and Jamie Cobey sold off his snake tools soon after the murder. Your Honor, when considering the totality of the circumstances, in other words, all of the evidence together, there is only one reasonable conclusion. The defendant is guilty, beyond a reasonable doubt, of murder in the first degree. Thank you.
Thank you very much, counsel. And lastly, then rebuttal from the defense.
Yes, Your Honor, may I proceed?
Whenever you're ready, counsel.
The people claim that Mr. Cobey had nothing to lose, but it's the exact opposite, because he had everything to lose: the respect of his neighbors, his best friend, Mr. Yazzie, his future, but most importantly, himself and what he stood for. Your Honor, Mr. Cobey is a man of nature. He would never even think of committing such a heinous act against Mr. Smith, regardless of what happened to his mother.
30 seconds.
Your Honor, these are all vital parts of Mr. Cobey's life that he could have lost, that the people ignored, because the facts don't line up with their narrative. They took the easy way out. But this isn't about doing what's easy, Your Honor. It's about doing what's right. And tonight, the people ignored this and did not prove beyond a reasonable doubt that Mr. Cobey is guilty. That is why you must find Mr. Cobey not guilty on all counts. Thank you for your time, Your Honor.
Thank you very much, counsel. All right. Excuse me, before I announce a verdict, an attorney from each team will be given an opportunity at this time to raise any trial irregularities. Please note that any procedural rule violations not raised at the time they occurred during the trial are now, of course, considered waived and may not be raised at this time. Should an attorney wish to raise any irregularities, they will have 30 seconds to do so. Attorneys must raise those irregularities on their own. They're not allowed to consult with their coaches. So I'm going to set a timer here. You all got 30 seconds to let me know if anything's going on, all right?
Your Honor, the people have no irregularities.
All right, defense, you have anything?
No, Your Honor.
All right, there we go. 8 seconds. Appreciate that. All right, the court, having heard and read heard the evidence presented in this trial, will rule as follows. As to count one, the court finds that the people have proved beyond a reasonable doubt each and every element to sustain a conviction for murder in the first degree, and therefore the court finds the defendant guilty of murder in the first degree. All right, first of all, let me provide some thank yous to our scoring panel. Again, these folks are amazing. I'm glad I'm not scoring. This is just what a heck of a round. So I'm going to ask the scoring panel if they'll be kind enough to exit the courtroom and return to the main Zoom room. Before you do that, my personal thanks, and I know thanks from all the participants here for you all volunteering to do this. The passion and love you have for this program and for these young men and women is evident. And again, thank you for taking time out of your busy days to help out.